I'm
good.
Representative Mary Murphy, and I call the Claims Committee meeting, Subcommittee meeting on April 7th, 2021 to order. Welcome to the committee. The first item on the agenda is approval of the March 26th, 2019 minutes as distributed.
Madam Chair.
Representative or Senator Anderson.
Thank you, Madam Chair. I move that the March 26 amendments of 2019 be recommended to pass.
All in favor signify by saying aye.
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 Aye. Opposed? The minutes are adopted. Second item of the agenda is the summary of claims. Mr. Keenly.
Thank you, Madam Chair. We'll start with the claims that have been recommended to be dismissed. Those include the Wright and Becker County claims. So I'll give a little bit of background on these claims before there's a motion to dismiss them. In 2016, Wright and Becker County has submitted a claim for reimbursement of attorney's fees for litigation in Otto versus Wright and Becker Counties et al. At the time of the 2017 and 2018 claims subcommittee hearings, the litigation was still ongoing. Then Senate File 154, House File 187 was introduced in 2019 that also provided compensation for the counties. That bill was enacted as Laws 2019, Special Session, Chapter 10, Article 1, Section 13. Because compensation has been received through an appropriation, the claim is recommended for dismissal. The other claim recommended for dismissal is the Sterry claim. In August 2019, Mr. Sterry submitted a claim for $1 million for compensation for being sexually harassed and sexually assaulted while incarcerated. Under Rule 4, Clause E of the subcommittee's rules, the subcommittee does not hear claims with respect to a proceeding that may be maintained by or on behalf of the claimant against the state in the courts of the state. Minnesota Statute Section 541.073, Subdivision 4 specifically addresses vicarious liability for damages for sexual abuse. Because this claim may be brought through the courts of the state, the subcommittee does not have jurisdiction over this claim, and dismissal is recommended. A motion is needed to dismiss these two claims.
Representative Quam.
Yes, Madam Chair.
A motion for dismissal.
I would so move to follow the recommendation.
All in favor of the Quam motion signify by saying aye.
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 Opposed? The motion is adopted. Mr. Keenly.
Madam Chair, I will now briefly summarize the claims to be held over. There are 5 injury claims where there is maximum medical improvement determination still pending. Those are the Jacob Brown claim, the Matthew Edwards claim, the Lind claim, the Washington claim, and the Salvador Proenza claim. There are 2 property claims with incomplete property records because they have sort of moved between multiple agencies. Those are recommended for holding over. There is a claim that was submitted in January of 2019 by the family of Correctional Officer Gom that filed a claim for compensation for his death. A bill for compensation has also been introduced by Senator Housley as Senate File 449 and Representative Novotny as House File 1191. Senate File 449 was heard in the Judiciary and Public Safety Committees this year. By tradition, the subcommittee defers to the broader legislative process and does not hear claims while bills for compensation of the same injury are pending. In addition, the subcommittee rules prohibit hearings based on workers' compensation and pension benefit payouts, both of which have occurred in this case. The subcommittee has not reached a final determination on the jurisdictional questions regarding this claim, but for these reasons, the claim has been held over. In 2019, this is the final claims that have been held over regarding Mille Lacs. There were 13 claimants that filed against the Department of Natural Resources claiming lost revenue. They were joined by another claimant in 2019. All testified to the economic conditions in the area and their personal stories of how the walleye fishing restrictions have affected their businesses. At the end of both years' claims hearings, the claims related to Mille Lacs were held over. Members spoke at the subcommittee. The claims subcommittee may not be the proper venue for the aid that the legislature may want to pursue regarding these issues. As mentioned in both hearings, the subcommittee has limited jurisdiction and can only hear claims specifically brought to the subcommittee. Other potential legislative remedies can extend beyond the limited scope of the claims subcommittee. For these reasons, these claims have been held over this year. No motion is necessary for these holdover claims.
Thank you. Is there any questions? Seeing none. I'm not sure. I've never done this before, so I've never chaired before, so I'm not sure. Senator Anderson, I see a hand.
Thank you, Madam Chair. Mr. Keenly, I'd like to know regarding the Mille Lacs Lake issue. Are you anticipating that something would come out of the legislature to address the concern here?
Senator, Madam Chair and Senator Anderson, there has not been anything introduced this year. There were a number of bills that have been introduced in previous years. Partially, the holdover is a continuing holdover from last year because of the legislation that was in place last year, or that had been introduced last year. We had scheduled for, if there had been a hearing, to hold those claims over. And now, given having not had a claims hearing last year because of the COVID-19, with the agenda this year, partially it was to continue to hold those claims over because we had anticipated holding them over last year. If they're, again, part of this is what is the legislature doing more broadly, and part of it is the facilitation of a meeting under the conditions that we currently have, and needing to have the claimants there and to be able to present those before further action takes place.
Okay, thank you much.
Any other questions?
No, Madam Chair.
If not, we'll proceed with the agenda. Are we on number 4, Mr. Keenly?
Yes, Madam Chair.
Okay, the exonerated claim.
Yes, and I'll summarize that, and then we can turn over to the testifiers to go from there.
Thank you.
Claimant Peterson pled guilty. This is an exoneration claim, and we can go into more details on what that is if there are questions about the exoneration process. Part of that is in the summary that I'll read, but if we need more detail on that, I can either provide that, or I think Ms. Anderson from MMB could possibly provide some background on that as well. So jumping into this, claimant Peterson pled guilty and was convicted of possession of a firearm by an ineligible person under Minnesota statute section 624.713. In 2016, the Minnesota Supreme Court held in State v. Hayward that a .177 caliber BB gun was not a firearm for purposes of section 624.713. Based on that decision, claimant petitioned for post-conviction relief. In 2017, claimant's conviction was vacated. Claimant filed a petition for an order declaring eligibility for compensation pursuant to Minnesota statute section 590.11. In September of 2017, the Minnesota Supreme Court struck down as unconstitutional a provision of section 590.11. During the 2019 legislative session, the legislature amended the provision and replaced the language deemed unconstitutional. An amended petition was filed in June of 2019. The petition was granted on August 30th, 2019. Claimant spent 572 days in prison on the conviction while not serving time for other offenses and 220 days on supervised release. The claim was filed with the Minnesota Supreme Court, and the court appointed a compensation panel. The compensation panel and claimant moved for a summary disposition of a settlement totaling $108,648.65. $93,242.65 is the statutory minimum for the amount of time in prison and supervised release, and $15,260 is for attorney's fees. The motion was granted, and hearing and payment are recommended.
Thank you. Ms. Anderson, Mr. Shane, do you have any additional comments?
Madam Chair, this is Kristen Anderson from Minnesota Management and Budget. Madam Chair, members, as Mr. Keenly identified, the order before you is part of a statutory process created by the legislature to allow for compensation for individuals who were wrongly incarcerated. These claims by statute come to MMB as a representative of the state, I assume, because we run the state treasury. And so we have really a fiduciary responsibility, not an adversarial responsibility in these claims. In this particular instance, the claimant sought only the statutory base rate and then reasonable attorney's fees, which are awardable under the statute. And so the parties were able to negotiate a settlement on those terms. Once a settlement is reached, excuse me, the settlement goes to the panel that is selected by the chief judge of the Supreme Court. And that panel issues an order consistent with the settlement agreement, and the settlement agreement is completely contingent upon a determination of an appropriation by the legislature. And so pursuant to statute, we have presented this panel order to you for consideration as an appropriation under the statute. And I'm more than happy to answer any questions that anyone has about the process.
All right. Mr. Shane, do you have any additional comments?
Good evening, members of the subcommittee. My name is Robert Shane. I do represent Mr. Nicholas Peterson, and the historical accounting of this case has been very thoroughly made and accurately stated. We are here to request this subcommittee to grant the joint motion for disposition in this case. We were in good faith during the settlement process, and as indicated, we only requested the base rate. We gave up our right to try this case in front of the compensation panel. Mr. Peterson was eager to resolve the matter. I know he has some comments, a statement that he's prepared that he would like to read to this subcommittee. But as you're probably aware, the decisions of the district court and of the compensation panel are not binding on this subcommittee. So it's the subcommittee. The representatives here, legislators, are the ones that have the authority, have the power to grant this joint motion. And I would just ask you to keep in mind the number of days that were stated that Mr. Peterson spent in prison, 572 he never needed to spend, along with 220 on supervised release. I've known him for several years now, and I think you're going to be very impressed with his statements about how he's turned his life around and how those funds can be applied to good use. So we'd ask you to grant the motion and approve the settlement. Thank you. That's all I have.
Thank you very much. Representative Anderson? Or Senator Anderson?
Are you looking for a motion, Madam
Yes.
Chair?
Yes, I am.
Madam Chair, I would move that the exoneration claim for Nicholas Mark Peterson be granted and passed.
Is there any further discussion? Mr. Shane, did you say that he does?
Good evening. Good
Uh,
evening, everyone.
Excuse me a minute, Mr. Peterson. Mr. Keenly?
Madam Chair, I was just going to mention that he had a statement.
Okay. So, Mr. Peterson, now, please,
Yes, ma'am. Yes,
please
ma'am.
say what you wish to tell us.
Yes, ma'am. Good evening. My name is Nicholas Peterson. Tonight, I am gratefully speaking to you in regards to my claim for compensation based on exoneration. In 2012, I was sentenced to 48 months in prison, to which I served 32 months inside and 16 months on parole. Those 4 years I missed impacted my life in many negative ways, not only for me, but more importantly for my loved ones who were dependent on me and relied on me for support, not only financially, but emotionally, physically, and spiritually. Instead of contributing, I was unjustly made a burden to my family and my state. My bills stacked up. My mother sent me money for necessities she couldn't afford to send. My college student loan fell into default as a direct result of this 48-month sentence. A big impact is that I had to miss the birth of my son as a direct result of this now vacated file. Inside, I had to suffer the uncomfortable living conditions, witness the violence, and likewise, I was physically assaulted, resulting in sutures. The big factors here are that I became financially burdened as a result of this prison term, and I was an absent father to my daughter and son that needed me very much. Today, I am a sober, productive member of my society. I raise my daughter and my son. I strive every day to be the best man I can. These funds we are here discussing tonight are very important for me to be the father, son, and best member of my community that I can. I have ambitions to pay my mom's debt, pay my defaulted student loans, and reattend school. I also hope that I can open up bank accounts for my daughter and son so they will have some security from me to be the best they can in the future. These funds would be 100% used for the betterment of my life and the life of my family. They would be cycled back into the economy, debts will be paid, investments accounts will be opened, and I give you my word, I will do my part and use appropriated funds as a stimulus to our great state of Minnesota. I'm very grateful for your time. God bless you, and thank you for listening.
Thank you for telling us.
Yes, ma'am.
I appreciate it very much. Is there any further discussion from the panel? If not, all in favor of the Anderson motion signify by saying aye.
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 Okay. The motion is adopted. The payment will be made.
Thank you very much.
Thank you very much.
Ms. Most, Mr. Keenly, are we supposed to have a roll call on those things?
I believe so, yes. We were directed to do that.
Okay. I'm sorry. I'm sorry I didn't catch that. Senator Anderson, Ms. Most, will you please call the roll? We will have a roll call vote on the Anderson vote.
Certainly. We'll start with Chair Murphy.
Yes.
Representative Frederick.
Aye.
Representative Quam.
Aye.
Senator Anderson.
Aye.
Senator Carlson.
Aye.
Senator Dornick.
Aye.
Madam Chair, everyone in the House and the Senate were in favor.
So the vote is unanimous and Mr. Peterson will be paid. Mr. Keenly. The next thing I would,
Madam Chair,
Mr. Keenly.
Chair Murphy, I think Representative Quam has a question first.
Representative Quam.
thank you, Madam Chair. And would it be appropriate for me to revisit my earlier motion so that we can do a roll call on that as well? I am hearing the rattle of a nod, Madam Chair. So I would so move that we with the appropriate language, reconsider my previous motion and vote on that with a roll call. Thank you.
Does that one need a roll call?
Madam Chair, this is for the dismissals that happened earlier in the meeting.
Yes, and does that need a roll call?
I believe so. It doesn't
Oh.
require them for the holdovers, but for dismissing the claims, I think
All
so.
right. Representative Quam, restate your motion, please.
I would move that we do a roll call on the motion for the dismissals that we held earlier.
All right, on item 3, is that correct?
Yes,
Yes.
Madam Chair.
All in
Okay.
favor of the Quam vote to reconsider signify by saying aye.
Madam Chair, I think we need a roll call.
Right, I will do the roll call. So we will start with Chair Murphy.
You're doing the roll call on the Quam reconsideration?
On the ones that we're holding over. Is that correct, Jason?
I think, Madam Chair, I think procedurally you are one step ahead, you are doing a step that everyone else hasn't thought about, which is you're reconsidering the original vote before we go to a roll call to
Correct.
do that vote again. So
Correct.
I think the oral, you can do an oral vote on the reconsideration, and then we'll do a roll call vote on the adoption of the motion for the dismissals.
Thank you. Thank you. You're correct. I was going for the reconsideration and I thought that could be verbal. All right, all in favor of the Quam motion to reconsider signify by saying aye.
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 Opposed? The motion is adopted. And Ms. Most, will you please call the roll?
Yes, we'll start with Chair Murphy.
Yes.
Representative Frederick.
Aye.
Representative Quam.
Aye.
Senator Anderson.
Aye.
Senator Carlson.
Aye.
Senator Dornick.
Aye.
So the House and Senate all were in favor.
And the vote is unanimous and adopted. The motion is adopted. Now, Mr. Keenly.
Yes, Madam Chair. I think we're now on agenda item 5, the claims against the Department of Human Services. I will summarize each of them, and we can either entertain 3 separate motions, or if there are none of these, we can hold them to if there's none of these that I think procedurally we should hear each of them. If anyone wants to motion that they be granted, we can do those as individuals. Otherwise, we can get to the end of all 3 of them and dismiss them as a group with one roll call vote. So I'll start with the Albert claim. Claimant Albert asked for $350 for damaged headphones. Claimant gave his headphones to staff to charge. A day or 2 later, after receiving them back, claimant complained that they had been, quote, destroyed. The headphones were evaluated by staff who noted tears in the fabric of the headphones. The headphones continue to function and claimant uses them, quote, constantly. There is insufficient evidence that staff action was responsible for the loss, and also insufficient evidence that there is a compensable loss that occurred. Denial is recommended. Moving on to the next one, the Anderson claim. Claimant Anderson asked for $2,152 for items disposed of by MSOP staff. Claimant was moved to a more restrictive setting. In that residential setting, the amount and types of properties are different than in the living assignment claimant had previously been in. MSOP staff inventoried the items that claimant had that were not allowed in his new living assignment. Staff informed claimant of the 90-day period for choosing a disposition of the claimant's property. Claimant did not respond, and nearly a month after the 90-day period had passed, MSOP staff disposed of claimant's property according to facility rules. Facility protocols were followed, and claimant had 90 days to direct staff on where his property should be sent. Denial is recommended on this as well. And then on the final MSOP claim, the Pyron claim, the claimant Pyron asks or seeks compensation for being required to send out either his Blu-ray player or DVD player after MSOP property policy changed from allowing a client to have both to allowing a client only to have one or the other. Because the policy change came from MSOP, MSOP paid for the shipping of the property out of the facility. Claimant is still the owner of both the Blu-ray player and the DVD player, even if claimant can no longer possess both while in MSOP. MSOP paid for the shipping cost created by the policy change. There is insufficient evidence that claimant has suffered a property loss. Denial is recommended. And if there are questions for any of these, I know there's staff here that could answer those.
Questions? If not, a motion on number 5, claims against the Department of Human Services is in order.
Madam Chair. Oh,
Senator Anderson,
I move that the claims against the Department of Human Services be denied and passed in such manner. With a roll call vote.
thank you for that reminder.
Okay, we will start. Yes, sorry. We will start with Chair Murphy,
Yes.
Representative Frederick,
Aye.
Representative Quam,
aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Okay, Madam Murphy, or Madam Chair, we have in the House and Senate all ayes.
Okay. The claims against the Department of Human Services with a unanimous vote will be denied. Number 6 on the agenda, medical reimbursement to the Department of Corrections or corrects for injury claims paid.
Madam Chair, these are expenses that the Department of Corrections pays out and then comes back for compensation to the subcommittee for. They total $1,183.63 for 3 different injuries, 3 different injuries that occurred in the medical expenses to cover those injuries. If you would like more detail, then Mr. Ehlers can provide that.
Okay. Mr. Ehlers?
Madam Chair, the Department of Corrections respectfully requests $1,180.63 for compensation for sentenced to serve or community work service program injuries and medical bills that we have paid out to those providers.
Thank you very much. And the requests were outlined in the report. Is there any questions? Representative Quam.
Madam Chair, I would move to approve this expenditure.
Okay. Is there any other questions? Ms. Most, will you call the roll for medical reimbursement number 6 on the agenda?
Chair Murphy,
Yes.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Madam Chair, we have all ayes from both the Senate and the House.
The Claims Committee has voted unanimously to repay the Department of Corrections for the amount asked for, $1,180.63 for the claims against that they paid for injury claims. Item number 6 on the agenda. Number 7 on the agenda, Mr. Keenly.
Thank you, Madam Chair. We'll do these each individual. These are injury claims that have come through the Department of Corrections. So we'll go through these in alphabetical order. I'll read a summary and then we can stop and do any discussion before doing motions on these again individually. So the first claim is the Dow claim. Claimant Dow was performing assigned duties when the mirror of the riding lawnmower that he was operating broke loose and struck him near the eye. Claimant was treated for lacerations at the facility clinic. Since the incident, claimant has complained of headaches of varying intensity. The headaches have been diagnosed as likely caused by post-concussive syndrome. The headaches have not been helped with medication. Medical records show that claimant's headaches do not affect his ability to perform, quote, activities of daily life. This is the standard for headaches to be compensated as a partial permanent disability. Because claimant's headaches do not reach the threshold for a partial permanent disability, hearing and denial are recommended.
Is there anyone that, do we hear from a claimant's person? Mr. Keenly? Do we hear any more information about the incident or the request?
Madam Chair, I can certainly go into more detail or Mr. Ehlers can as well. Typically for the people who are still incarcerated, we don't have them appear. We don't set up appearances at the subcommittee. We can certainly, if there are questions regarding the claim, we can either certainly hold them over to answer any questions that you may have regarding the claim, or if you would like more detail, I can go into further detail, or again, Mr. Ehlers can as well.
I read it in the book. And is there any other questions about this? Then does someone want to move? All right. Seeing no motion,
Madam Chair,
Representative Quam.
I would move that we follow the staff council's or committee council's recommendation
Thank you.
on these. Thank you.
So the motion is to deny the Dow claim.
Correct.
Ms. Most. Please call the roll.
You're muted, Ms. Most.
Just noticed that, sorry. Okay, we'll start with Chair Murphy.
Yes.
Representative Frederick.
Aye.
Representative Quam.
Aye.
Senator Anderson.
Aye.
Senator Carlson. Senator Carlson.
Sorry. Aye.
Okay. Senator Dornick.
Aye.
Okay, Madam Chair, we have all ayes from both the House and the Senate.
And so with a unanimous vote, the Dow claim is denied.
Chair Murphy, Madam Chair, the next claim is the Nicholas Edwards claim. The claimant Edwards asked for compensation for a partial amputation of his right index finger. Claimant was performing assigned duties in the grommet shop. Claimant's right index finger was smashed in a grommet machine. He was transported to the emergency room where hospital staff determined the proper treatment was a partial amputation. Claimant has otherwise healed well. DOC staff recommended payment of $3,750, but compensation under Minnesota statute section 176.01 subdivision 2A was increased for injuries occurring after October 1st, 2018. Under the amended compensation amount, claimant's index finger injury equals a 5% rating for the whole body, equaling a partial permanent disability payment for $3,940. Hearing and payment are recommended.
Any questions? If not, the recommendation is payment of $3,940.
Madam Chair, I would so move.
Representative Quam moves the payment for the Edwards complaint be paid for $3,940. Ms. Most?
Yes, we'll start with Chair Murphy,
Yes.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson.
Aye.
Senator Dornick.
Aye.
Both the House and the Senate are in favor.
And the sum of $3,940 has been approved by the Claims Committee for Mr. Nicholas Edwards.
Madam Chair, the next claim is the Fleischman claim. Claimant Fleischman asked for compensation for a fractured humerus. Claimant was returning from performing assigned duties when he fell and injured his right shoulder. X-rays and a CAT scan showed a fractured humerus. 2 months later, X-rays showed that the fracture had healed. Claimant has a range of motion within normal limits. There is insufficient evidence of an injury generating a partial permanent disability rating. Hearing and denial are recommended.
Any other questions? Is there a motion?
Madam Chair, I would move to deny the claim.
Anything else? Okay, Ms. Most? Motion has been made to deny the Fleischman complaint.
Start the roll call with Chair Murphy,
Yes.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Both the House and the Senate are in favor.
And because of the vote, the unanimous vote, the Mark Fleischman will not be paid for his complaint. Mr. Neely.
Madam Chair, the
Sorry.
next claim is the J-Chort claim. Claimant J-Chort asked for compensation for a partial amputation of the distal tip of his right thumb. Claimant was performing assigned duties in the facility kitchen when he sliced the tip of his thumb on a vegetable slicer. The portion of the thumb that was amputated was about 6 millimeters across and 1 millimeter in area. The minimum compensable injury under the workers' compensation schedule for a thumb amputation is an amputation greater than 1 centimeter. Because claimant's injury is smaller than the minimum, there is no evidence of a partial permanent disability. Hearing and denial are recommended.
Any questions?
Madam Chair, I would move to deny.
Representative Quam moves to deny the request of Mark Jeckort. Ms. Most?
Start with Chair Murphy,
Yes.
Representative Frederick.
Aye.
Was that I'm sorry, would you please repeat?
Aye.
Aye, okay. Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick,
Aye.
Madam Chair, both the House and Senate are in favor.
With a unanimous vote, the Mark Jcourt claim is denied.
Madam Chair, the next claim is the Stephen Colquet claim. And he is represented in here at this hearing. So we'll have probably testimony after I do the summary here.
All right, thank you.
Claimant Colquet asked for $277,683 for compensation for amputation of 3 fingers on his left hand and loss of wages connected to the injuries. Claimant was performing assigned duties in the facility wood shop where he severed 3 fingers and part of a 4th on a beam saw. Medical records show complete amputation of the claimant's middle ring and little finger on his left hand and significant damage to his index finger at the PIP joint. The physician in claimant's records used the pre-1993 rating schedule. Under the current schedule, claimant's injuries rate as follows: complete amputation of the middle finger, 11%, ring finger, 5%, and little finger, 5%. These percentages are added for a total of 21%. The damage to a claimant's index finger is rated separately. Claimant's index finger injury is rated under intrinsic tightness for 40% of finger loss and loss of function for another 40% of finger loss, value of the finger. These are combined as 0.4 plus the quantity 0.6 times 0.4 or 64% of the index finger, which is rated at 11% of the whole body, which equals 7.04% of the whole body. This is combined with the 21% as 0.21 plus the quantity 0.79 times 0.0704, which equals 26.5616% of the whole body. Finally, this is combined with a 2.75 rating for moderate loss of sensation in the index finger. And that is combined as 0.265616 plus the quantity 0.734384 times 0.0275, which equals 28.581156% of the whole body. The base for a 2013 injury between 25.5 and 35.5 is $100,000. So the permanent partial disability amount rounded to the nearest dollar equals $28,581. Claimant was asked for records to show previous work experience and income from those jobs, the job loss or the previous jobs to substantiate the lost wages claims. The documentation provided is insufficient to make a finding of a recommendation for the amount of lost income due to claimant's injuries. Hearing and payment of the $28,581 is recommended.
$28,581.
Yes, Madam Chair.
Okay.
And that's the permanent partial disability rating for the injuries.
Is he with us tonight?
No, but Mr.
Yes, Senator
Mr.
Anderson.
Kemp is here.
Who?
Mr. Kemp, Michael Kemp, attorney. Is he?
Madam Chair, I am present before the committee. My client was present before the committee. He is here by video. We have requested brief testimony on the issue that was presented to this committee, Madam Chair, which was a question of the wage loss that he has claimed. So I'd ask permission from the chair and the committee to briefly summarize the claims and then to allow my client a few minutes to testify as to why he is entitled to a wage loss claim in this case.
Please proceed.
Thank you, Madam Chair and members of the committee. It was already outlined to you that in this case, my client, Steve Colquet, was injured in an accident in a prison workshop on August 5th of 2013. Mr. Colquet suffered traumatic amputation of 3 of his fingers and a partial amputation of his 4th or his index finger. There are questions about the calculations on the permanent partial disability. There do not appear to be questions about the jurisdiction of this committee or that some payment is appropriate. The question then is how much? There have been no other payments made to Mr. Colkay. So in addition to the question of compensation under the PPD schedule, because of the traumatic amputation of 3 of his fingers, Mr. Colkay, who had previously worked all his life as a carpenter, has been unable to find any substantial employment. He has worked for several years to try and find employment, and while he has found several jobs, which are temporary and have given him payments in the amount of just over $8,342 as of the time of the submission of this claim. He has not been able to find full-time or permanent work because of the injury he sustained. Madam Chair, and with the permission of the committee, I would like to then ask my client or seek his testimony through brief question answer to address why we do not have the ability to show any previous documentation because his incarceration so long ago does not give us the chance to put forward records before the committee. So may I proceed, Madam Chair, with testimony from my client?
Yes.
Mr. Colkay, as we just told Chair Murphy and the committee, we're just focusing on a very narrow issue right now, and that is how your injuries affected your wage loss. Could you tell the committee first to confirm where and when were you injured?
I was injured in MCF Fairbolt in the industry wood shop on August 5th, 2013.
In the industry wood shop, were you working there as a carpenter?
Yes, I was working as a carpenter in their cabinet shop.
So I'd like to explain to the committee then why you were working as a carpenter in that prison. Do you have any experience working as a carpenter before?
Yeah, I had been a carpenter since I was a teenager, and since 1997 up to the point of me going to prison.
And that was in 2013, is that correct?
Yes.
All right, so I'd like to just very briefly go over for the benefit of the committee what experience you had as a carpenter in those 26 years. First, you said you started working as a teenager. What was your first, what you would consider full-time job in carpentry?
From the ages of 16 to 19, I worked for a company called Northern Precast. I was a carpenter in their wood shop building architectural precast concrete forms.
And after that time, when you turned 19, where did you go to work?
I got a job for a company named Team Sierra. I was in residential construction. I was a framing carpenter and field supervisor for them.
And for the benefit of the committee, can you very briefly describe what your jobs were in framing and as a field supervisor?
I was in charge of anywhere from 5 to 7 other employees, and I ran my own job site. We built single family homes, did the framing work on the single family homes, and prepped the site and the job for the subsequent subcontractors.
And Mr. Colkay, when you say doing the framing, could you briefly explain what you mean by that?
We build the walls, the floor system, and the structure of the roof. We sheet the entire outside of the structure and install windows and doors.
Is this a job that requires you to work with your hands?
Yes, very, a lot, yes.
All right. Then going forward after 2005, did you have any further work that you did in carpentry?
Yeah, the housing market was really good back then, and I started my own business, a company called Crespi Builders that I ran from 2005 to 2008. And then in 2009 and 2010, I owned a contracting firm called Colkay Brothers Construction.
All right, so from 2005 to 2008, what were your job duties in carpentry?
I ran the day-to-day operations of my company. I did bookkeeping. I bid all the work that my company did, and I managed one crew on the site. I also did the hiring and firing, and came into the job and did all the framing, like I said before, with put up the walls and the roof system. And I supervised all the employees and their job duties on the job until completion.
And then in 2008 to 2010, you told the committee that you managed Koke Brothers. Can you explain briefly what you did?
Yeah, I was after the housing market crash, so I couldn't afford to keep on as many employees. And so we started a contracting firm doing mostly remodeling, framing work again. But it was just me, my brother, and we usually employed 1 or 2 other carpenters. It's a lot smaller company, a lot more hands-on, but I did project management for the entire job as opposed to just the framing. So I was a residential building contractor.
When you say you were a project manager during those years, 2008 to 2010, could you briefly explain what that means?
Yeah, I would work with the customer from the bid process through design. I would meet with the architect and kind of be the go-between between customers and the architect and the subcontractors. I would develop a scope of work, schedule the job out for the different subcontractors, then do quality control throughout the project.
Can you say 1 or 2 jobs that you have done?
We did a larger framing job. We did with Sarna's Classic Grill. We did the framing. We won the framing contract on that at University and 40th in Northeast Minneapolis. We were paid $53,000 for that job, and we did a lot of residential remodels in the Wooddale neighborhood in St. Louis Park.
So these aren't just putting up prefab houses. This is custom work you're describing?
Yeah, most of the jobs for custom jobs, we tried to shoot for custom work because it paid better.
And it sounds like the job description, your work experience that you're describing, it was more than just sawing boards and hammering nails.
That's a fair statement.
Could you do the job that you performed from 2005 to 2010 with only one hand?
No, because a lot of the work I had to do on the hands-on work I had to do would be come behind the other contractors and fix the stuff that they had missed. And it's just really difficult to do with one hand when you're using power tools.
Now, Mr. Koke, in December of 2010, though, you were convicted of a felony. Is that correct?
Yeah, 2 felonies: first-degree burglary and check forgery.
And that conviction initially resulted in a stay of your sentence, so you did not go to prison immediately. Is that right?
No, I was put on probation.
But in 2011, did you have a work injury, a back injury?
Yeah, I had a lumbar spine injury, L4, L5, and S1.
All right. And as a result of that injury, did you also become addicted to opioids?
Yeah, I did. I became an opioid pain medication addict after my injury and the amount of pain medication I was on for the amount of time.
And then you ended up getting an executed sentence as a result of probation violations. Is that right?
That's correct.
And it was during the execution of that sentence that the injury that we're talking about today happened. Is that fair to say?
Yes.
All right. So because the issue that we're focusing on is what your wage loss was, when was the last time before the prison sentence that you were convicted of in 2010? When was the last time that you had? Oh, I apologize. What we're trying to explain to the committee is the last years that you had full meaningful employment before the conviction that led to the injury we're talking about here.
What was my income those years?
If we're talking about 2008, 9, and 10, can you explain to the committee?
Yeah,
what your
my
income was?
net personal income in the years 2008, 2009, and 2010 were 80,000, 100,000, and 110,000 respectively. That was after payment of my overhead from the company.
You've sought documentation of those amounts to see if there's anybody who has the documents that can prove 10, 12 years ago what you were making. Have you been successful in doing that?
No, I haven't. I contacted old contractors I'd worked for, and I contacted my old accounting firm. And the IRS and the accounting firm are required to keep records older than 7 years. I couldn't get my hands on them.
All right. So after you were released in 2014, can you describe how you had been treated medically? What was the medical treatment for your injury?
After the injury, they tried to reattach the middle and ring finger. The next day after the reattachment, the ring finger came off, and then the middle finger a week later. There were a few follow-up appointments to remove sutures and whatnot, and a little bit of physical therapy. But that was about the extent of the medical treatment besides the trauma surgery.
Were you prescribed opioids for the pain?
Yeah, I was on oxycodone and a fentanyl patch when I was at the Oak Park Heights Medical Unit, and I was on tramadol when I was moved back to Faribault.
So when you were released from prison as somebody who had previously struggled with opioid addiction, did you have any problems maintaining sobriety?
Yeah, I did. I mean, I was already opioid dependent when I walked out the door. Not a real good position for someone like me to be in. I eventually ended up graduating to heroin, and I continued to use until 2018.
What happened in 2018 that got you clean?
My fiance got pregnant. Now we have a 2.5-year-old daughter. I've been clean since March 28th, 2018. And we've got another daughter on the way in July, on July 9th.
Have you been looking for work since you have been released in 2014?
Yes, I have, and I have found work to some degree, but nothing substantial or full-time.
Are you able to work as a result of your injury in your field of construction?
No, and I've tried with a couple different companies, and I just wasn't able to carry out my job duties in full.
Who's been supporting you during this time?
I've gotten a little bit of help from family, and my girlfriend works a little bit. She has a part-time job, but most of the time I've been dependent on a little bit of help from my family and whatever part-time work or temporary work I can find.
Mr. Kolke, as part of this claim, we submitted to the committee numbers from the Bureau of Labor Statistics that the mean salary of a carpenter yearly was $5,120, and the numbers from the Minnesota Department of Employment and Economic Development listing an hourly wage of $24.66 per hour to an annual salary based on a 40-hour work week of $51,292.80. So to be clear to the committee, although you have significant experience in project management and things like that, you're not asking that you be compensated at the levels that you were making money at before you went to prison. Is that correct?
No.
Is it your request to the committee that based on the government numbers published by the federal government and the state government, that you be compensated for $51,292.80 per year minus the $8,342 that you've actually received in order to calculate your wage loss?
Yes, that's what I'm asking.
Thank you, Mr. Kolke. You can mute your audio now. Madam Chair and members of the committee, this claim was submitted in November of 2019. That current amount, or the amount that was requested at the time, was $277,683. Your Honor, Mr. Kolke respectfully requests that he be compensated not only for the traumatic amputation of his hand, but that as somebody who has spent his entire adult life working in one field where he can no longer work, that he also be compensated for the wage loss that he has suffered since in the annual yearly amount of $51,292.80 per year minus the $8,342 he has made. Madam Chair and members of the committee, do you have any questions for me that I can answer?
Yes, Mr. Kemp, we do. I do. Take us from 2010, when he was working as a carpenter, to 2013, when he had his accident in the prison, or had the fingers removed, the incident of loss of fingers. What happened in those 3 years?
Madam Chair, members of the committee, it was December of 2010 is when the initial conviction was, and Mr. Kolke was on probation at that time. In the year of 2011, as he said, he had suffered a work injury, and as a result of which he was not able to be fully employed. As he talked about, he also, due to that injury, and as unfortunately has happened to so many Minnesotans and Americans, started out taking pain pills and became addicted to opioids and eventually to heroin during that time. He had continuing legal troubles because he was still on probation. And even though he was not subject to probation violations for use of controlled substances, his use of controlled substances led to him being held in custody for several probation violations during that time until the sentence was finally executed starting in 2013. In short, Madam Chair, during that period of 2011 and 2012, Mr. Colquet did not have significant the sort of significant gainful employment that would be helpful to showing what was his pre-injury wage.
Okay, so when did he lose his fingers? In 2013?
August 5th of 2015 was the accident.
And that was when he was incarcerated.
That's correct, Madam Chair.
What kind of injuries did he have from the accident in 2011 or?
2011 was a back injury, Your Honor, that we are not seeking compensation for, of course. And Jack Burt, who submitted a report that was attached as Exhibit A to our initial claim, does note that lower lumbar back injury.
And in your letter to Ms. Most, you said that he was working while he was incarcerated, that he was working as a carpenter?
Yes, that's correct, Madam Chair.
Mr. Ehlers, I have a question about that. When the questions of Mr. Kemp are done with. Does anyone else have questions of Mr. Kemp? Senator Anderson.
Thank you, Madam Chair. From what I'm gathering here is that the construction company, or the Colquet Brothers Construction Company, lost or basically went out of business in 2010, or did the brother continue to do construction work, or did the whole company just dissolve?
Madam Chair and Senator Anderson, I don't have the answer to that. What I can tell you is, as Mr. Colquet has testified, he did not, as a result of his injury and then opioid addiction that resulted from that, did not have full employment either with Colquet Brothers or anyone else during that time, from which this committee could reasonably look at as a baseline for the wage loss. Senator Anderson, of course, what we are trying to present is a baseline of how we might calculate what a reasonable wage is.
So, Madam Chair.
Senator Anderson.
Regarding his injury, was that in 2010 or 2011 for his lower back?
Madam Chair and Senator Anderson, the back injury was in 2011, and the injury for which we are here seeking compensation was in 2013.
So, Mr. Kemp, I'm confused because in 2010, the Colquet Brothers were still in business as far as I can see, except that in December of 2010, something happened there work injury that's what I wrote down, December 2010. But I would think for the year from the January 1st on to December, there was full employment for the Colquet brothers. Am I wrong?
No, you're not. In 2010, Mr. Colquet testified that his portion of the income from the business was $110,000, and that was for that year, which went until December of 2010, at which time he was convicted of the felonies he mentioned. 2009, he also had employment for that full year. He testified $100,000 was his portion of the Colquet brothers' income. And in 2008, he testified $80,000 was his portion of the Colquet brothers' income.
So
I should say, I
Senator
apologize.
Anderson.
go ahead, Mr. Kemp.
I apologize. I should have corrected myself there. That was his total income for those years.
So, and Madam Chair, Mr. Kemp, I'm guessing that there has to be some kind of a record that had been kept by the Colquet brothers that either his brother still has or someone that was employed by them to keep the books and things like that would still have records to gainfully show some kind of evidence. From what Mr. Keenly said, there was no evidence or no records found to be able to show what he had made. This is his word against us asking questions.
Mr. Kemp.
Madam Chair, thank you. Senator Anderson, I would not characterize it that way, because what we are asking for here is not the compensation based on what he says he earned in 2008, 2009, 2010. Senator, I would agree with you if we were here asking for yearly compensation as a baseline wage loss of $110,000 per year. Mr. Colquet's testimony was intended to explain to this committee what it was that he did, that his job was as a skilled professional working with his hands, and one for which he made, at that time, a lucrative income. But he's not asking for that now. What he's asking this committee to do is rely on a publication from the same state government that you are here representing, and the federal government Bureau of Labor Statistics, which both offer almost identical numbers for what a carpenter like Mr. Colquet can expect to make in an average year. We're asking that and not Mr. Colquet's memory of his previous income be used as a baseline for what a carpenter in Minnesota would have made for the last 6.5 years.
Are there any other questions?
Madam Chair, I guess I am confused because I would think there would be some kind of record, even though we're not basing it on previous construction or previous work that he's done and years of construction. But it would be nice to at least have some kind of records to verify that he was actually a construction individual.
Madam Chair.
Mr. Kemp.
Senator Anderson, I absolutely agree. And we would love to be able to come here with this documentation. The best evidence that we have that he was a carpenter is that the prison put him to work as a carpenter. And as to the documentation, all I can say is I've been doing this a while, and there are people who I ask for their tax returns for last year, and they can't produce them. So it's unfortunate, but not surprising to me that records from 2008, 9, and 10 are not available.
Does anyone else on the committee, on the Claims Committee, have questions of Mr. Kemp?
Thank you, Madam Chair and members of the committee.
Thank you very much. Mr. Ehlers.
Yes, Madam Chair.
It's been indicated in the letter from Hanson Dorrell and Michael Kemp that he was employed at the prison when he was incarcerated as a carpenter. Is that correct?
In a sense, it's a work assignment for which they're compensated. It's not a typical employee-employer relationship. It's a work assignment is how it's characterized. So he is compensated for that work in the wood shop.
And what compensation did he receive?
I don't have that specific information at the time. Depending on the type of work, it can range anywhere from the beginning starting wages of, I believe it's somewhere in the neighborhood of 25 cents per hour, but depending on, it can certainly you step up every few months or so and get increased hourly wages. If it's an interstate job or the what's being produced is placed into interstate commerce, then there are higher wages for that. If the committee would find that wage information helpful, I can certainly work with the facility to get those specific records and provide them to you if that's something you would like to review.
And what kind of work do they do in the workshop?
I'm not entirely sure. But
and are they still doing that kind of work now? I mean, that was in 2013, right?
It's my understanding they are still, the wood shop at Faribault is still operating. That's my understanding. I believe they make a variety of different, Madam Chair, a variety of different products. And I mean, I suppose even Mr. Kolke could provide specific information about what he was working on at the time.
But were those products that they made then sold?
Madam Chair, I believe that is the case.
Yeah. As part of MinCor.
Madam Chair, yes.
Okay. All right. That's all the questions I have. But Senator Anderson has questions.
Madam Chair.
Mr. Ehlers or Senator Anderson.
Well, someone was trying to get your attention. It wasn't me.
It's Senator Dornick, Madam Chair.
Senator Dornick.
Madam Chair, I can give a little clarification. I'll have a question too, but I'm a general contractor. I'm a carpenter. I've been a carpenter all my life. And obviously I'm a senator now, ran for the Senate. So I can appreciate the testimony of Mr. Kolke and his representative there. To be a carpenter with one hand would be very difficult. The numbers he's saying are correct. And as far as the numbers, the big spread there, I don't think that's my job to pick a number. I don't know for sure. But there's definitely to have one hand to be as a carpenter, like I said, is difficult. But as we heard the testimony, though, Mr. Kemp, he was a project manager and a supervisor. So my first question would be, I know he said he's kind of tried, but I would think with his skill level that he would be very valuable on the job yet, even with not all his fingers on his hand. And I'm sorry to hear that for that young man and just what he went through. But so that's my question. I know he mentioned that he was a project manager and a lead carpenter, so I would still think he'd be very valuable on the job.
Do you want a comment from Mr. Kemp about that?
Kemp. So Mr. Kemp or Mr. Kolke, which either one, but just, I mean, I know they're just.
Mr. Kemp, did you hear Senator Dornick's question?
I did, Madam Chair. And Senator Dornick, I can ask Mr. Kolke to provide in a sentence or two what he has sought is a project manager role and what he has found. Senator
Mr.
Dornick,
Cooke,
Yes.
would you
Mr.
like to answer Mr. or
Yeah.
Senator
Well, I
Darling's
was.
question?
Yeah, I sure can answer that. The jobs that I was seeking was as a framing foreman. And mostly in residential construction, the foreman is expected to perform any labor duties that he can dictate to anybody else, you know. So I was still expected to be on the job, managing the job, but be on the job and performing all the labor duties as well.
Thank you, Mr. Cooke.
All right.
Senator Dornick, did you want follow up on that from myself or Mr. Cooke?
So, man, I just know there's such a shortage of people. I'm thinking there's jobs out there that you'd be valuable, because I know as I got older, I don't do the work as much with my hands as just lining things up. So I'm just hoping that maybe you can continue to try to look, because I know there's a shortage of carpenters, good carpenters. So, so my other question would be, or no, I guess that's not a question either. So I guess that's my thoughts is, I'm like I said, I don't know what my job exactly is here, but I do think that it's the price for the hand is too low, but I don't know if that's, you know, but I guess that's all the comments I have. Congratulations, by the way, Mr. Cooke, for your turning your life around and getting some children in your life. So congratulations on that.
Thanks a lot. It's been a real blessing.
Senator Anderson.
Thank you, Madam Chair. Mr. Keenly, you know, you just used a formula that is put out by labor standards or whoever, healthcare, for the hand, and as far as getting money for that. Is there any type of a formula other than what Mr. Kemp had used to say this is the amount of money that he should be making as a carpenter in this real world? Is there any type of formula that you have in regards to work related injuries or work type situations for individuals that have been incarcerated and have gotten out?
Senator Anderson, Madam Chair, Senator Anderson, you know, we use the workers' comp system because it's a no-fault system, and you know, it does allow us to have something that we can, you know, generalize formulas from. You know, we have not often, you know, in large part because of, you know, many of the claimants are still incarcerated when, you know, when they're going through and recovering from their injuries. But there, within the workers' compensation system, there are a number of different levels of compensation. One is the partial permanent disability that we most often do, but there's also temporary disabilities, which is, you know, a temporary partial disability, which sort of pays a level of the wage differential. And so that is a 66% of the sort of difference between what was previously earned and what you were previously earning. And so, you know, there's also a floor minimum that we have not, as a subcommittee, ever given, which is, you know, once you're below this level, we sort of fully compensate you. So, you know, that is something that the subcommittee could certainly do, and there are formulas that we could use to do that as a, you know, again, based on the workers' comp for temporary disability. Those are somewhat time limited. There's a specific amount of time for which you can get those payments until you sort of flip to the partial permanent disability. We sort of, in most cases, we can skip the temporary and just go to the permanent, which is why the amount is low, as Senator Dornick said, because in most circumstances, in general employment, you're getting temporary disability for a specific time before you are eligible for permanent. Because these injuries are permanent injuries and we would know we would pay them, we go ahead and pay them even if the temporary benefit hasn't fully run yet. Again, we haven't ever done the minimum payment using the workers' compensation system, but that is something that to run those numbers, we could certainly look at that. Again, what we've typically done for is to use the other portion of that formula, which is a 66% replacement of previous wages, which is why the previous wage number is important for specific actual wages. And we haven't used this is the type of work that I can do. In that it's been what have you done just prior to what is your most recent relatable work experience, and we've made compensation determinations based on that.
Senator Carlson.
Thank you, Madam Chair. I have a question that requires actually two answers. The first one is, I'll ask the question first and then ask Mr. Keenly about it. Was this the dominant hand? I can understand if someone is a carpenter and you injure your hammer hand, that's a bigger problem than if you injure your other hand. And I'm wondering if in our formulas, when we're talking about the loss of use of a hand, does it make a difference whether this is the dominant hand or not? And which hand did Mr. Kulke lose the use of?
Mr. Keenly.
Madam Chair and Senator Carlson, the formulas do not discern between dominant and non-dominant hands. And in this case, it may be in the record, but I don't remember it offhand.
And Madam Chair, Mr. Kulke.
Senator Carlson.
Mr. Kulke, thank you, Madam Chair. Mr. Kulke, could you let us know whether you injured your dominant hand or was it your other hand?
Mr. Kulke.
Yes, ma'am. It was my non-dominant hand. The difference in workability with a dominant hand versus a non-dominant hand is kind of negligible. I still have to be able to feed nails into the nail gun. I'm using the right hand with my left hand. I don't really have left.
Okay.
Thank you.
You're welcome.
Representative Quam.
Madam Chair, I didn't have a specific question. Just the thought that, frankly, we should have maybe some compensation addition. I'm open to that. I do think that, as Senator Dornick brought up, there are job site functions, and it might be with a larger company of where he could perform a supervisory project management or other task, because I do know many people in carpentry, after so many years, it takes a toll on a person, and so that they transition into those other job functions. And I would think that would be reasonable to expect that is still possible, but it would take some transition. So I was hoping that maybe Senator Dornick, since he's somewhat familiar, would have a suggestion on a compromise amount. And I think that's sort of what the sentiment I'm hearing and feeling from the questioning is. And that I just thought I would bring that up, Madam Chair.
Mr. Keenly, what I'm hearing is that there's not a satisfactory amount that we're talking about if we were talking about paying an amount. And so what's the next step now?
Madam Chair, there's a few potential next steps. If there is, a few things that the subcommittee would like me to take a look at, we can certainly hold the claim over. We can attempt to come up with a number here, and I can, attempt to provide some guidance for that if there, is a level of discussion that if you've got some ideas of what that would be, certainly there is a number that has been, or a calculation that has been made by the claimant. That's certainly something that we can certainly look at as well. I think that again, that those numbers are, there is evidence for those numbers as far as the $8,000 of sort of annual payment, and then the Bureau of Labor Statistics. That those are again numbers that are based in in calculations for averages. So again, what the subcommittees, where the subcommittee would like to go on this, and what that calculation is. Again, I don't know the number. I'd have to go back and look at the as far as if we default back to a workers' compensation model, what that number is for temporary, the amount of time before temporary benefits run out, to figure out what amount of time we would be paying if we're going to use a number to do that, and how long that compensation would be. We could certainly look at something. Again, there are a lot of different components and a lot of different ways to look at this, depending on what your thoughts are on the direction that you would like to go as to coming up with a calculation on this. The recommendation that I made, that we don't have, that there was not evidence submitted that resulted in a wage loss compensation, was again based on what the subcommittee has typically done, which is again based on immediately prior compensation compared to current compensation. In which case, in this case, there's not a difference there that is sort of calculatable based on the records that were submitted.
But, and then, when was this first submitted to you? To the Claims Committee?
Madam Chair,
I was so busy looking at the pictures that I didn't pay attention to the dates.
The department response, which I have a date on, was January of last year. I would have to go into the
2019.
Yeah, so December, it was received to December 16th, 2019.
Yeah, okay. For the first time.
I believe so.
And this happened in 2013. The
Right.
amputations happened in 2013. And so we're not getting it until 2019.
Madam Chair, I believe that's correct. I have not served as counsel for that entire time, so there's a chance that it was submitted before my time, or that it was submitted to the Department of Corrections. Again, in the intervening time before it came here. There are some cases, I know that there are some injury claims that we're dealing with now that were 2017 claims that were sort of immediately submitted and sort of worked their way through the system. So I don't know the procedural history on this. This came directly, I believe, to the claims subcommittee before we sent it back to the Department of Corrections for them to go through their process and submit their recommendation, which again they did about a month and a half after this was submitted to the subcommittee.
Okay.
Which was again a year and almost a half ago now that we didn't have a subcommittee hearing last year.
Right. Okay. Representative Frederick.
Thank you, Madam Chair. I do have a question. I know that a lot of the discussion so far has been focused on money and where to go with the money, but I have a question. I don't know if it would be appropriate for Mr. Ehlers to answer this one, but is there any information that can be provided around the context of what happened when the fingers were taken off, or what caused that? And was it equipment failure, or if there were any details to put this whole accident kind of in context?
Mr. Ehlers.
Madam Chair, thank you. I'm looking at his file now. I don't have the specific information right now, but it does appear, I do have an understanding that there was an investigation into the incident and there was a corrective action plan made to prevent any incident from occurring in the future. However, I don't, right in front of me, I don't have that specific information about what caused it. I can, if you'll indulge me a couple of minutes, I can certainly dig into that and should have an answer for you.
Mr. Fredericks, Representative Fredericks.
Thank you, Madam Chair. I guess I have a hard time supporting the original ask for the dollar value, but I also understand some of the concerns like that Senator Dornick and others have brought forward about the recommendation. I think it was like 28,000. So I think the context of if it was equipment failure or something like that outside of anyone's control, I think that adds context, and we should take that under consideration when we're trying to evaluate where the dollar value could be. But if it was other issues, perhaps inattention or whatever the reason was, I think that's also important context. Thank you, Madam Chair.
Mr. Keenly.
One of the reasons, thank you, Madam Chair. One of the reasons that we use the workers' compensation schedule is that it's sort of based on a no-fault system, so that, you know, because some of these instances are difficult to sort of suss out. You know, the sort of goal of the workers' compensation system in at large is to sort of lower the investigative cost of these things. So, you know, it sort of runs both ways of, you know, there are instances where the person who is injured is at fault that they get compensation in a larger amount, and there are times where the you know, employer in a workers' compensation system, in this case we're using it, you know, for the state, you know, it takes on more liability than if you sort of litigated the entirety of what the you know, what the causes were. So that's sort of the underlying, again, philosophy of sort of the workers' compensation system generally, and, you know, why, you know, unless there's a showing of intention sort of one way or another, you know, we generally don't look too far into the specifics of that, in large part because, you know, in these situations, especially for something that is, you know, at this point, you know, 8 years old, you know, the circumstances surrounding that may be difficult to determine.
Okay, any other questions? Mr. Keenly, I think we're not quite ready.
Madam Chair.
Representative Quam.
I thought that Senator Dornick was going to suggest an amount. I'm not sure if he has the hand function. He might be running through his phone.
Madam Chair.
Senator Dornick.
Just to make a little clarification on the last little, it doesn't matter whose fault it was. If you're hurt on the job, and all the jobs I worked for many different contractors, they're going to pay. So it's really hard for me without a formula to come up with a number, but, and I don't know, is that something we can even do on this? Can I recommend a number, or what is our role here exactly with this one particular, I guess?
Recommend a number, but it still has to be worked out between the Department of Corrections and our council and the claimants.
Okay, thank you, Madam Chair. So how much longer is this going to be if we table it? When's the next time that this is heard?
Mr. Keenly.
Madam Chair, I mean, you know, there's certainly a history of holding over claims. We're holding over 5 injury claims from that have come in already. Typically, as far as from this hearing, we'll set up dates in Ways and Means and Senate Finance for moving the recommendations from this hearing forward this year in a bill. I think given the timing of this hearing and the what is left of session, it's unlikely that there would be a second hearing on this, but that's certainly not my call on that. But as far as process for when things holding over claims is certainly something that happens relatively often in this, if you're just asking from the procedural side.
Right. So it would be next year for sure. But
Okay, so
if
there's-
they're not, Senator Anderson.
Thank you, Madam Chair. Well, if we're going to wait till next year, then I was hoping that the gentleman from Mr. Eilers would come up with some information about the cause of the injury to Mr. Kalki. But maybe he doesn't have the information. Maybe he can't find it. But I would recommend maybe holding the bill over till next year.
I think that would be, and then the things can be worked out between the department, and we can get more history on it from the department, or a better history than what we were given tonight, and what's in our book.
Right.
And maybe we can reread what's in our book, because I'm sure we have all the information that's been presented, but then maybe Mr. Anderson and Mr. Kinley and Mr. Kemp can work together, or with the department, Mr. Ehlers, and see if more probable workers could be. But Mr. Kemp, I don't think that you should, if we hold it over, we're still going to be considering what advice we get from our council on payment. And I don't think you should be adding this extra year in on your list of that has to be paid in. Because this is a 2013 injury.
Madam Chair, thank you. If you were asking what would holding over do and whether it would add a year, I would certainly defer to committee counsel on that. I do certainly, if Senator Anderson wants, have the details of what did happen on that day. I can also say that I know from my client's perspective, especially with the second young child on the way, I think he would rather not have it hold over, even if it means that there isn't the ability to be fully compensated, rather than wait a year and then we're back here maybe having the discussion again. This is a claim submitted in 2019, and so I would.
We don't work fast in the legislature. We have bills that we carry every year for 8 or 10 years sometimes before they become realistic.
Yes,
so
Madam Chair.
It's not a fast thing. Mr. Kinley, do you have any more advice for us?
Madam Chair, I guess, if there are, if the committee decides to hold it over, if there are specific options, because I can certainly, in the interim, come back with, a number of different options based on, again, different approaches from what the subcommittee has taken in the past. If there is suggestion on direction for that, that would certainly be helpful in sort of narrowing down the, the possible, iterations of, what a recommendation, would look like, and sort of, again, what we have a factual basis for, in this claim.
Mhm. And has any other number been given to you other than the number that you expressed to us at the beginning of this hearing?
Madam Chair, no, there's certainly the claimant number, and then the DOC's number, matches the number that I recommended, which is, again, there not being evidence based on, what the subcommittee has typically used for these wage loss determinations. Now, that
And that was
doesn't prohibit.
That was 28,581, right?
That's for the actual injury part, and is zero for the wage loss, again, using what we have typically used, using what the subcommittee has typically used for that type of determination. So there's a whole world out there of other options. If you would like me to, again, explore those, I was basing my recommendation on, again, what the subcommittee has previously used, which is, the actual a wage loss based on a previous wage minus, any existing wage for those type of situations.
Representative Quam.
Thank you, Madam Chair. And there are two members of the committee are freshmen, and they're not quite sure of the process. In my decade or so involved with this committee, I thought that past precedents that we have gone 2 or 3x dependent on circumstances, and that's part of the purview of this committee, is to look at the situation and come up with a reasonable and just approach. I think the delay of a year isn't advantageous for the future and the moving on. I guess I am thinking that it would be reasonable and not precedent setting to do 2 or 3x of what the 28K that's before us, and that would allow for a transition in the employment and to resolve this. But I'm putting that out for a discussion in the hope that there might be something that could be done this year. And so I notice hands flying up, and I will sit back now. Thank you.
Senator Anderson.
So just want to be clarified, Madam Chair, from Senator Representative Quam. Is he talking about 28,000 times 3 to give a reasonable number for job loss? Am I understanding that?
Representative Quam.
Thank you, Madam Chair. And it appears that in the past, I think we had done a similar type of thing several years ago. We have hundreds of claims each time we meet, but I thought that we had done that in the past, and that's why I was hoping that Senator Dornick, with his direct experience in the industry and what options present and evolve out, that we could in a reasonable order of time come up with a possible discussion. If we can't, then it'll be a year. I was just one more shot at trying to take care of it in this year.
So, Madam Chair.
Senator Anderson.
Madam Chair, Representative Quam, if you were to take 28,000 and multiply it times 3, that's $85,743 for job loss over 6 years.
Senator Carlson.
Thank you, Madam Chair. I think we're getting closer and closer to this. I tend to agree with Representative Quam that this committee has a lot of freedom to act on this. And I think we've been talking back and forth about whether this is something that we really feel good about having a smaller number. And just thinking out loud, I'm not particularly concerned about some of the job lost in the past as much as I am concerned about getting this man working. And I think that should be something that we should think of here. And I think Senator Dornick was going after the right thing, that this man has to have a job sometime in the future, and what that will be is going to be his future. And if it's something that might be into sales, or might be into estimating, might be into project management, somewhere I think he'll be able to find something that he can put his future on, and he has to do that, really. So if there's something that we can do to make sure that not that he gets paid for all the years that he was missing income, but that he gets set up a bit to be put back into a position where he can earn enough to supply for his family. And I think what Representative Quam suggested and what Senator Anderson said, I think is right on. If we take a multiple and move that and get this off the table and get this man set up so that he can get either trained or find a position and get employed again, I think that that's the best thing that this committee can do for him.
Mr. Kinley.
Thank you, Madam Chair. One other option that may be available to the subcommittee that is not something that we have done in the past, but is something that's recommended for another injury claim that we're hearing in a bit, is to make a partial payment and to pay out the medical part now and to come back with the wage question next year is another option. Again, that's not something that we have typically done. Typically, we've done full and final payments. But it's recommended to do it in a claim a little later in this hearing. So that is another option as well. If you want to do the 28,000 for the injury portion, because that we know what that number is. If you want to work on the formula and the number for the other portion of that, we could certainly do that and hold over just that part of the claim, or we can try to do a multiple, this session and be done with it, and do a full and final payment like the subcommittee typically does.
Senator Dornick.
Madam Chair, at the beginning of the start of this, I had in mind the $100,000. That's kind of what I had. I know it's like, I have a friend that lost 2 or 3 fingers on the trades, on a table saw. He's a good carpenter. It just sometimes it happens. It's not anybody's fault. It's just an accident that just happens. And it's a bad deal, tragedy. So that's what I had. I like Representative Quam's number 3 times, but it's up to the members here to decide what's right. But that's where I'm at. I'd like to get the guy to move on to something else. He's waited. It's been a long time ago. So I'm in favor of just paying him a number that, if we have the authority to do that, let's get it done tonight. That's my thoughts. Thank you, Madam Chair.
Senator Anderson.
Thank you, Madam Chair. Well, I like Senator Quam's idea. I like Senator Carlson's, Representative Quam, and Representative. I like the fact that Senator Dornick is looking at 100,000. I'm thinking that if we do the multiple and we do the $85,743 for his job and the $28,000 for $581, That's $432. We're a little over $100,000, Senator Dornick, but we're including the medical along with it. So it's not what he asked for, but at least he's going to get something for a good start, as Senator Dornick said, to get him up and get him going. I'll make that a motion.
I didn't get those. I didn't get past the 85,000. What else were you adding in there?
The medical that he's going to get. We know the number for that one that Mr. Keenly gave us, which was $28,581. He's going to get that for his medical loss of his fingers.
Right, but then you're adding
the 85,000 for the multiple that Representative Kwan was saying. Take the 28,000 and multiply it by 3. It comes up to 85,000.
Right. So why would you go over that?
The only reason it would go over is when you add the medical into that. Otherwise, they're separate.
But this is the 28,581 was the medical.
And we're going to pay that. And then the 85,000 would be for the job loss.
Any other comments? Mr. Kemp?
Madam Chair, members of the committee, the committee's put a lot of time and thought into this. We would stand on the claim as it's been submitted and support Senator Anderson's motion.
Senator Anderson's motion is for how many dollars then, Senator Anderson?
Motion is to pay the $28,581 for his loss to his hands while incarcerated. And with a multiple of 3, it would equal $85,743 for his wage loss from 2014 when he was released to today.
Councillor Keenly, have we paid for wage loss in the past?
Madam Chair, we have paid for wage loss. Again, how we've calculated that, we've used a temporary partial disability in the past as far as figuring out what amount of time that we would make those payments and sort of again what that offset payment would be. Again, the subcommittee is certainly, we use them because they give us a baseline to not be arbitrarily making decisions as far as what, especially on the injury front, what's the difference between a lost finger versus a back injury versus those kind of things. So it sets a baseline of what are we working with, and what a thought out system for valuations. Again, there are a number of different ways to calculate wage loss. So we have done wage loss in the past, and there's a extent to which sort of each wage loss is its own, requires its own calculation because you're taking different things into account. So, there's certainly nothing keeping the subcommittee from making, using this as a reasonable determination for the amount to pay. So, I think, this would I'd have to spend some time running some numbers to sort of figure out what this would look like in comparison to, to other awards that have been given, and sort of what this would sort of presume that the claimant's, salary was, if we're thinking about, how we would base it, how the subcommittee has based it in the past. But given the circumstances, again, the subcommittee has spent a lot of time discussing this and trying to come up with, what the subcommittee feels is a reasonable, response to this.
Madam Chair.
Senator Anderson. Was that you?
No, it's Senator Dornick.
Senator Dornick?
Yeah, I liked Representative Quabb's 3 times. Just seems like it's more of a formula. That's what I was thinking when he brought it up. I just thought that's a good way to do it. I just was saying for context, I was just thinking 28,000 is way too low. 277,000 is way too high. And I still thought it was too much in between, but I didn't know if that was really our job to set a number. So I like the 3 times. That's just my personal opinion. I would rather just get it done for tonight. So Senator Anderson, I don't know if.
Thank you, Senator Dornick. I tend to agree with you.
I don't know if Senator Anderson would be moved to amend it or change it to that number, Madam Chair.
Senator Anderson has his hand up.
Madam Chair, what are we multiplying by 3?
28,581.
That's what I did.
And then you added.
I added if I take the 28,531 and multiply it times 3.
581.
Or 581, that gives me $85,743.
That's as high as I'll go.
And then the other money, if that 28,581 is for the fingers, are we going to leave that out then? We're not going to pay that?
No, we're using that as the fingers, and then the fingers and the wage loss.
Oh, you want that combined with 85,000?
I would accept that, but that's as high as I'll go.
Madam Chair.
Senator Dornick.
Yeah, that's exactly what I'm saying, and I agree with that, Senator Anderson. That's what I'm just saying. I didn't realize you're going to add the number to it. I thought it was just times 3. That's where I'm at too. I like that number. I like that formula.
So that's 8,5,7,43. Senator Carlson?
Yeah, thank you, Madam Chair. I think I guess I have to be clear on it. If we have a motion on the table and what that motion is we're really talking about either 3 times or 4 times.
We don't have a motion on the floor yet.
I thought Senator.
Well, Senator, yes, we did. Yes, we did. Then Senator Dornick popped in, and then I was going to amend it to the 8,5,7,43. Then I saw Dornick's hand go up, and then he said he agreed, and I agreed with him, but we still have
I can,
Bruce Anderson.
Madam Chair, I can make a motion to either amend Senator Anderson, or I can make a new motion to do 3 times the 28,581, whichever order we need to do it.
What would you prefer, Senator Anderson?
Madam Chair, I can pull out the 28,531 and just leave it at 85,743.
Friendly amendment, Madam Chair, is that it? Friendly amendment?
Friendly amendment.
Right.
Dornick's friendly amendment. Is there any other comments? Mr. Keen?
Madam Chair? Did you
Oh,
need me?
no, I just wanted to see if that would, if
I have that
Mr.
recorded.
Kemp, if Mr. Kemp would accept that.
Madam Chair, members of the committee, I suppose I would say that the nice thing about being on a committee is it doesn't matter whether I accept it or not, because you guys have the ability to say what you will recommend or not. The only thing I would point out to the committee is this. It does make sense to use a multiple of the actual injury as a wage loss. That's not an uncommon thing to do. The Senator Anderson's motion with the amendment then results in a wage loss over 6 years of about $57,000. I think that sounds a lot lower. It's about 9,000. It's basically a presumption that he would have only earned $9,000 a year. That said, as I said before, would certainly encourage a vote rather than holdover on whatever the committee believes. And we will, and Mr. Colque will accept whatever it is that the committee decides to do tonight.
All right. Thank you very much. Ms. Most, the Anderson amendment as amended, or the Anderson motion as amended by Senator Dornick, 85743, for the claim of
Madam Chair?
Senator Carlson.
Yes, thank you, Madam Chair. I guess, more of a procedure question. When we move this and accept this figure, who actually does the final agreement? And does that final agreement mean that this is a last and best, and that there's no further actions that can be taken against the state? And I guess I'm not sure if that's Mr. Keenly that does that, or who actually makes that agreement.
I think it's Mr. Keenly, isn't it? Mr. Keenly?
Madam Chair, Senator Carlson, I don't make the agreements, but what we put is in the legislation. So
Right.
typically what we do in the bill is that this says it's for full and final payment. And so that in interpreting that, it sort of rolls down the line to, whether that's, I think those get processed through MMB, but, the direction is for full and final payment. So if they don't sign away that this is full and final payment, then the payment doesn't get made.
And Mr. Allers, do you have any comments to make about the Anderson motion as amended?
Madam Chair, this is certainly a difficult claim to parse through given the lack of documentation. However, I would note, this is certainly a committee based on equitable principles, and certainly has the deference, and I will give deference to the committee's determinations on the wage loss portion. In terms of the partial permanent disability that Jason has recommended, I certainly concur with that. But I will defer to the subcommittee's judgment on the loss of income issue. And so I have no objection to the Anderson amendment.
Is there any further comments from anyone? If not, Ms. Most, will you call the roll for the Anderson motion as amended for
Yes.
the Stephen Colque claim?
Okay, we'll start with Chair Murphy,
Yes.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and Senate are in favor.
All right. The motion is adopted and we have agreed on 85,743 for the Cole K claim. Mr. Kinley, before we
Madam.
go, the next item on the agenda is claims against the Department of Corrections for Philip Fishman, or for James Vandervender. And did you tell Mr. Fishman how much time we had? Did you give him an amount of time or?
Madam Chair, according to the agenda, we've got a couple of claims to do between those two alphabetically. But we can, if we want to skip to I think they'll be relatively quick. So we can either do them or we can do the Vandevender claim and come back to the O'Reilly and the Schmidt claim.
Okay. Yeah, because we're going in order, or in alphabetical order, right?
So if you would like to do the Vandevender claim,
Okay.
because Mr. Fishman is here we can.
And it's the Vandevender that's going to take the longest time, right?
Hopefully not. And it's Mr. Fishman's birthday.
Oh my gosh.
And hello, and I'll try not to be as long as the previous matter. We've made some really wonderful progress, I believe, myself and counsel for the committee. So with your indulgence, and we have a nice.
Just hold on a minute. Hold on a minute.
Okie dokie.
So, Mr. Kinley.
Yes, Madam Chair.
So who is supposed to be next?
The O'Reilly, we still have the O'Reilly and the Schmidt claims if we're taking them in alphabetical order.
And we better, because otherwise we won't be in the right spot in the book. Right? I'm sorry, Mr. Fishman, we'll get to you.
It's okay. Thank you.
So,
or if your family is waiting for your birthday party,
We'll be all right.
it'll be a few minutes longer.
That's all right. Thank you.
But I was just trying to get back on the clock with the regular time. Okay, Mr. Kinley.
So, Madam Chair, the next claim is the O'Reilly claim. Claimant O'Reilly asked for $4,500 for compensation after his little finger was pinched and fractured while performing assigned duties. This claim was held over in 2018. At that time, medical records still showed an area of numbness, and the time since the injury had not been sufficient to reach maximum medical improvement. Claimant was released from custody in September of 2018. Since then, the Department of Corrections have attempted to contact claimant several times to request medical records that would substantiate a finding of permanent disability. Because the claimant has not responded to these requests and there is not sufficient information in the record to make a determination on disability, hearing and denial are recommended.
Mr. Ehlers, do you have any comments to make?
Madam Chair, I don't. I'll just note that our last request that was sent out to him was in December 2019. And this was a claim that we submitted to the subcommittee in 2019.
Okay. Is there a motion? Is there any questions?
Madam Chair.
Senator Anderson.
Madam Chair, I move that the claim for Richard O'Reilly be denied and we go to a vote, roll call vote.
Ms. Most.
Yes. I'll start with Chair Murphy.
Yes.
Representative Frederick.
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Madam Chair, we have both the House and the Senate in favor.
So the motion is to deny the Richard O'Reilly claim. Mr. Neely.
Madam Chair, the next claim is the Schmidt claim. Claimant Schmidt asked for compensation due to a back injury sustained while performing assigned duties. Claimant was mowing the facility football field when he stepped in a hole and felt 2 pops as he fell. Medical records contain evidence claimant has resulting lumbar and radicular pain. Claimant has a prior history of back problems, including a spinal fusion of his L5-S1 joint. Medical records show claimant has multiple permanent injuries that are compensable under the workers' compensation schedules. Lumbar injuries can be rated under any of 3 categories, but these categories cannot be combined. The 3 categories are fractures, lumbar pain syndrome, and radicular syndrome. Claimant's current condition equals a 10% rating under lumbar pain syndrome or a 12% rating under radicular syndrome. However, in both of these categories, claimant's pre-existing pain and spinal fusion result in at least a 12% pre-existing impairment, which would reduce claimant's rating to 0. Under fractures, medical records show that claimant suffered an L3 compression fracture and an L2 anterior inferior corner fracture. Each of these equal a 4% rating. The L3 fracture under part 5223.0393 subpart 2 item A sub item 2, and the L2 fracture under 5223.0393 subpart 2 item C. While subpart 1 restricts the adding categories from the same subpart except as specifically provided, subpart 2 item D permits adding 3% for fractures to multiple levels. Claimant's maximum partial permanent disability rating is equal to a 4% plus 3% for a total rating of 7%. In 2016, when the injury occurred, the base for a 7% rating was $80,000. So the final calculation is $5,600. Hearing and payment are recommended. And I believe as a council for DOC has changed for this one. So if you have questions, I believe.
Okay, Ms. Ruthven.
Thank you, Madam Chair. The DOC agrees. It's a slightly, Mr. Keenley's recommendation is slightly different from that made by the DOC, but does agree that at least the records indicate 2 fractures. 1 fracture was small, but believes that the recommendation by Mr. Keenley is appropriate.
Okay. Senator Anderson.
So am I to say that on the front of the page here where it says amount of claim is $3,000, that was from the DOC, not from Mr. Keenley?
Madam Chair, Senator Anderson, that's correct.
Thank you.
And so the amount that you said, Mr. Keenley, it should be what?
$5,600, Madam Chair.
$5,600. And is that acceptable to Mr. Schmidt? Or has that passed by them, or there's no one here representing him?
Madam Chair, Mr. Schmidt remains incarcerated.
Oh, okay. And you accepted the 5,600, Ms. Ruth, then?
Thank you, Madam Chair. Yes, the DOC can concur with that recommendation.
Okay. Senator Carlson.
Thank you, Madam Chair. I recommend the payment of the recommended amount of $5,600 for Mr. Michael Schmidt. And we can confirm it with a roll call vote.
Is there any further comments? Okay. Ms. Most,
Okay, Chair Murphy,
yes.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Both the House and Senate are in favor.
So Ms. Ruthven, representing Mr. Schmidt, $5,600 has been unanimously voted for the claim of Michael Schmidt. Mr. Neely,
Madam Chair, now we're on
Keenly.
to the Van de Vendor claim. So I will give a brief summary and then you can let the others that are here to testify to this have their moments. So claimant Van de Vendor asked for over $500,000 for a traumatic brain injury caused when he was assaulted by another offender with a wooden board while performing assigned duties in June of 2012. Because of the severity and ongoing nature of claimant's injuries, he has a very long medical history. Claimant raises compensation prospects under permanent total disability and 3 permanent partial disability categories: impairment to cognition, emotional disturbance, and seizures. Unlike most of the injury claims heard by the subcommittee that have only a medical component, the injury categories in this claim have both medical and functional components. 3 of the 4 claim categories include functional components that are difficult to determine while the claimant is residing in a Department of Corrections facility. The functional portions of the ratings are largely the source of disputes in this claim. First, permanent total disability is determined by a person's perspective of obtaining employment. Because claimant cannot currently attempt to be employed, any attempt to determine his employability for purposes of permanent total disability at this time would be speculation. For the impairment to cognition claim, the functional question is whether, quote, the claimant requires some supervision on a daily basis of activities of daily living. If so, this would sustain the 40% rating ascribed by the claimant's Dr. Cohen, the inspection or the medical records put forward with Dr. Cohen. If not, this would equal the 20% rating suggested by the department. Because of the highly structured nature of claimant's current living environment, there is insufficient evidence in both directions that claimant requires or does not require daily supervision. For claimant seizures, to have a rating, a finding of a restriction to driving and working in exposed heights is necessary. Currently, there is insufficient evidence of this type of restriction. However, if claimant is denied a driver's license because of his history of seizures, then compensation for seizures could be appropriate. Typically, the subcommittee authorizes full and final payments and resolution of a claim. However, under workers' compensation law, minimum ascertainable permanent partial disability can be awarded before a final determination of the severity of an injury can be determined. It is within the subcommittee's authority to pay a similar award. In this case, a minimum ascertainable payment would be appropriate for a 20% rating for impairment of cognition and a 20% rating for emotional disturbance. Medical records relied on both sides substantiate the medical portions of these ratings, and there is sufficient evidence in the record for the functional components, as both claimant and DOC include these or higher ratings. Claimant at a minimum has, quote, mild impairment of complex integrated cerebral function demonstrated by psychometric testing and able to live independently but requiring supervision with executive function. Under part 5223.0360, subpart 7, item C, subitem 2. In addition, claimant has mild emotional disturbance present at all times, but can live independently and relate to others under part 5223.0360, subpart 7, item D, subitem 2. The Department of Corrections suggests that these ratings should be reduced by 10% each for claimants pre-existing ADHD and depression respectively. However, there is insufficient evidence in the record to rate these pre-existing conditions at the 10% rating that the department suggests. Therefore, both impairments should be rated at their full 20%. Under the rating schedule, the 20% rating for cognitive impairment and the 20% rating for emotional disturbance would be combined as 0.2 plus the quantity 0.8 times 0.2, which equals a 36% rating of the whole body. In 2016, when the injury occurred, the base for a 36% rating was $120,000. This would result in a minimum ascertainable permanent partial disability amount of $43,200. Hearing and payment of $43,200 is recommended with any future final determination of disability reduced by this amount.
All right. Any questions? Mr. Fishman?
Yes, I've heard the presentation by council, and I believe that is accurate, although I would, under the 03607C3, Dr. Cohn did give a 40% disability, and under the work comp schedule, and maybe there's a year might show this to be more the case, but one who is living independently but requires some supervision on a daily basis, it would seem from the past that Mr. Van der Venner did have supervision on a daily basis with respect to his mother handling many of his executive functions. I know Dr. Cohn has indicated that he more likely than not will, upon release, need a very strong structure, some supervision, and Dr. Cohn has seen him as a candidate for a structured or a structured, working because of the nature of his memory loss, his deficits, and his cognitive disabilities. So the only immediate, say, concern I have for the committee's consideration would be my thought would be, as per documentation for Dr. Cohn's study, a 40% rating for the cognitive impairment based upon what he's shown in prison, what he's basically was relying on his mother and others at his prior time. Other than that, Jason and Mr. Cooney was very thoughtful in his understanding and his approach to this, and he did indicate holding over the determination on permanent total disability, because that's a very sizable sum of money, and perhaps 1 calendar year for the committee to get us more facts as to what kind of job he can do, what kind of supervision he'll need, will he even get a job because of his ex-offender status? Will this job require him to get welfare benefits in addition? So that probably makes sense, given the expenditure. I'd have a hard time arguing that there probably is more probative evidence that could be made for the permanent total disability claim in a next session. I think that's correct. I also agree that the rating for seizures, and I think very, very thoughtful of council to hold that over, because at the current time, we don't have restrictions for the epileptic seizure. However, I would anticipate with the material that I gave before the committee, it's quite likely that he'll develop some form of additional problem. And I would think that a work comp potential employer would never hire him for any heavy duty driving restrictions or around machinery because of the ever-present possibility of seizures. But I agree, on the record before the committee, there is no present restriction noted. I think it's also very thoughtful to hold over the question of what will his expenses be in the future, that he's gonna, after he gets for release, and then estimate of future medical expense, which would be speculative at this time. The history says that folks who have epileptic seizures, which he developed after this post-concussion and this monstrous attack with these wooden boards 6 times on his head. I don't know if the committee saw that video or not. It was presented to the committee. It is lucky he is still alive. So that's what I have to say. I see the the problem facing me for the future, and Mr. Vandervenner. The only immediate issue I would have would be the potential 40% impairment as documented by Dr. Cohn for the cognitive impairment. Given the $500,000 that was spent, he was in a coma for 45 days. And this committee, I'm sure, has a great deal of sensitivity, as I've sensed from your previous assessment of the prior claims before you of this person's condition. So I think that's all I need to say. I think it's brief, and if anyone has to ask me a question, I'll be more than happy to respond.
Any questions of Mr. Fishman? Senator Anderson.
Thank you, Madam Chair. Mr. Fishman, are you suggesting that we hold this claim over rather than pay it?
Oh, no. I certainly, I'm the 43,200, that's go Gophers. That's wonderful. That's whatever.
I can't hear you.
You're muted. Mr. Fishman.
Here we go. We back?
You're back.
Okay, yeah, back. 43,200, yes, definitely that's recommended. We would love to have that paid. If the committee was of a mindset to entertain payment of some form of permanent total disability, that would be fantastic. I don't know your thoughts there. So no, I'm just looking at the memo that I got from Council where he indicated that he was of a mindset to hold over some of the issues, but recommended payment of the 43,200,
Okay.
which of course we're in agreement with.
Any other questions? Thank you, Mr. Fishman.
Thank you.
Mr. Kinley.
Yes, Madam Chair.
This is one where you are recommending that we split, that we hold over?
This is one that I am recommending that we hold over some of the issues and do a partial payment. Part of this is that the claimant here has a scheduled release date in December. And this is also, a claim that, to go a little bit into the procedural history in front of the subcommittee, this was heard in 2014 and 2015 in the subcommittee. And so there have been a number of hearings on this. I think, at this point, there are a number of issues that we, as I stated in the brief summary, there are a number of issues that are very difficult to determine while the claimant is still incarcerated. And so in trying to find a balance between the length of time in the multiple hearings that this has been through and trying to clear out some of the issues for, a future hearing where we have time to figure out those questions of whether the claimant can get a driver's license or whether the seizure issues whether they've been controlled well enough on medication for him to get a driver's license or not. Those are kinds of things that are not knowable now, but are knowable at a time in the future. But at the same time, again, because this is a 2012 claim, or it was a 2012 injury that has now been here 3 times, and with a scheduled release date in December, making sure that there seems to be a benefit to at least making a partial payment here for the things that are not under disagreement. And I think the Department of Corrections Council can go into some more information on release dates and that kind of information if there's questions about what the next steps will be between now and a future hearing where we will have clear evidence or clear lack of evidence, which is sort of what we're missing right now is lack of evidence or clear again lack of evidence. So that's sort of the given that sort of both sides are in at least partial agreement on part of on a substantial portion of this, it would be strange to hold over a $5,000 to pay a $5,000 claim, but here we're talking about a $43,000 partial payment, which I think would be is legitimized in the record and is something that is within the subcommittee's jurisdiction to do, even though it's not something that the subcommittee has done in the past.
Thank you. Ms. Ruthven.
Thank you, Madam Chair. Moving off of what Mr. Keenly had to say, Mr. Vandevender is scheduled to be released late-ish December of this year, 2021. And given when the subcommittee meets right around this time, the department questions whether if you hold this over, I do not believe that 3 months post-incarceration would necessarily be sufficient time regarding to establish his employment history. I did speak with Mr. Keenly before the meeting, and he had recognized that it would be the department's preference would be if this were held over, it would not be at the next claims subcommittee meeting, which would potentially be only 3.5 months after Mr. Vandevender's release, but the subcommittee meeting in 2023, I believe. So if that's right, sorry, it's hard with the timing. So I just want to put that out. Mr. Vandevender, while he will be released from incarceration in December, or is scheduled to be released, his current projected release date is in December of this year. He is on supervised release, which means through 2025. Should he violate his conditions of release, he could be returned to custody through the expiration of his sentence. In the past, he had a prior incarceration. Actually, the injury happened while his release had been revoked for an earlier violation. So, but his current he was incarcerated, injured. His sentence expired. He is in on a new incarceration. This is not one full period of incarceration since his injury.
Okay. Now, am I correct that I heard somewhere in here that this is the 3rd time the claim has come before this committee?
Madam Chair, you are correct. The claim first came in front of the committee, I believe, in 2014, at which time there was not sufficient information. The committee was seeking additional information, and the parties were indeed seeking additional information. After that hearing, Mr. Vandevender's treating provider, Dr. Schlosser, provided additional information. It came before the committee again in 2015. In 2015, at that point, Representative Quam recommended an $18,000 payment to Mr. Van de Vender, but the claim was withdrawn before the subcommittee could vote. Madam Chair, at the time that Representative Quam made his motion, Mr. Van de Vender was represented by a separate attorney, and before the subcommittee could vote on the pending motion, the attorney went up to the podium because it was pre-pandemic and withdrew the claim and proceeded, attempted to proceed with a claim in federal court that was ultimately dismissed.
Oh, okay. So no money has gone to him for this injury.
Madam Chair, that's correct. No money has gone to him.
Okay. And the earliest that if we don't take the partial payment, if we pay the partial payment, the earliest that anything could come back with real accuracy would be 2 years from now.
Madam Chair, that's
from December. Well, 23.
Madam Chair, yes, 2023, because he would be at that point, he would have been out of custody, assuming the meeting were to happen in April 2023, he would have been out of custody for roughly 15 months, as opposed to having only been released from custody for 3 months, which the department would present. We don't believe that that would be a sufficient amount of time to show the ability, both employment ability and the ability to keep a job. I would note, particularly, one of the things that is difficult for previously incarcerated offenders, just due to their incarceration status and the fact that he will be on supervised release, which is often referred to as parole. Those individuals do have difficulty finding employment separate and distinct from any potential injury, merely because he has multiple felony offenses and will be on release.
Correct. Mr. Fishman.
Thank you. With all due respect to counsel for the Department of Corrections, there's a real dilemma here. If he has to wait 2 years to get any permanent total disability benefits, that's very difficult for him to integrate. In addition, he'll have trouble by virtue of being an ex-offender. It's legion in our society that many employers won't hire. So to make this gentleman wait 2 years from now to get the benefits that arguably he might be able to establish in the next 6 months seems to be problematic. Now, why is it problematic? Because it'll create great difficulties. Let's look at the evidence that I presented to this committee in some rather lengthy submissions. I indicated to you that even the treating neuropsychologist, Dr. Pichello, said that Mr. Van de Vender's pre-injury employment was de minimis. It was sporadic. He got very little in terms of work. He had general employment. It was low wages, and essentially he even had to have benefits in addition. So with respect to his pre-employment history, it almost fit the definition of somebody who had sporadic employment. Now, in prison, he had de minimis work. He was working at the various jobs. He's paid 50 cents an hour, very structured, so there's no real time experience at that point. Now, by virtue of this injury, through these boards, this man is profoundly injured, profoundly documented on his memory loss, cognitive abilities, depression, can barely finish his sentences and words. And this man is going to be released, I agree, in December of this year. However, isn't it more likely than not that he is going to face a very difficult uphill battle getting any kind of employment other than what he ever had, which is sporadic. I believe that there's evidence before this committee, and this is state money, and we're asking for a lot of money. But the problem is he has very real injuries. Everyone in this committee knows that. He has meets the legal definition, I believe, of permanently totally disabled at this point. But then again, you say, all right, you're asking for several $100,000. Whoa, you got to swallow. You want to make sure you're right doing that. But I believe that it's a real hardship for him to have to wait 2 years from now. I believe there's sufficient evidence now for a good start for this argument. And I think within 3 months after he gets out, he can work with a job counselor. You can see the kind of money or lack thereof that he'll be earning in that 90-day period. I just think it's a hardship for what this fellow's gone through to have to wait, 2 years. And then something else which is real sensitive here. I've sensed in this committee, and I'm just going to put it out straight, a real sense of justice and concern for the folks like Mr. Vandeventer. This injury was caused by some unsecured boards in a prison. The 8th Circuit Court of Appeals wouldn't allow the lawsuit to go forward because there wasn't a significant showing of deliberate indifference. But the court clearly said in their opinion, this was negligence, but we couldn't sue for negligence. Somehow in my heart of hearts, I believe that this injury would have never occurred if the state correctional people had followed that basic, simple tool policy. So what do you make of this? What you make of this is, how are we really going to do justice by this guy? And I'm not saying empty the bank this afternoon. I'm just saying this is a real moral and ethical question as well for the state of Minnesota. And I understand that this board is charged with an immense responsibility. And I know you're going to consider these things. So I'm asking for a quicker resolution of the larger issue rather than a 2-year wait. And that's really my thought. And thank you for listening to me.
Ms. Ruth Finn.
Madam Chair, to the extent that Mr. Fishman was referring to Dr. Piccolino's report, I would note that he was referencing Mr. Vander's pre-occupational history. Mr. Vandeventer was first incarcerated with the DOC in August 2007 when he was 20 years old. He remained incarcerated with the DOC through July 2010. He was released on supervision and reincarcerated a year later. He was injured in June 2012, and the DOC recognizes this was he suffered a terrible injury, and we do recognize that. I would note, and it was detailed in the department's response, we do not believe that an award of permanent total disability is appropriate in this case. Mr. Vandeventer managed to secure employment 6 months after this terrible injury and managed to retain that employment and continue in that employment. Granted, he moved from a different role, but at one point, his providers noted he was working 55 hours a week in this barrel company. And really only, it was his reincarceration which limited his employment. His post-injury employment was his longest term of employment when he was an adult and not incarcerated. So his longest tenure in a job was after this injury, not before. So the DOC, and again, recognizing it may be difficult for him to secure employment for reasons totally unrelated to this injury, but do not believe that 3 months is necessarily appropriate. I would also note, again, his treating physician in 2014 did not believe that there were adequate deficits that to provide a significant disability percentage, and noted that in 2014, again, his treating, not a DOC treater, his treating doctor said that any deficits should not impact his ability to maintain gainful employment. DOC recognizes that Mr. Keenley's recommendation to keep this portion of the claim open, and but does not believe any award of permanent total disability is appropriate now, and again would recommend and request that if a portion of this claim is held open, it should be held open to that meeting in 2023, simply because I do not think that the information that could be gleaned in those 3 months post-release will really get to the meat of the question before the committee. Thank you.
Mr. Fishman.
One quick retort to Council's last comment. When Van Deventer was released after his last job, it was in the barrel factory, and she alluded to he couldn't do all the jobs. In point of fact, he could no longer continue to do the laser because of the memory loss. Moreover, and more significant, when he was returned into custody, he had a completely different situation occur, namely an epileptic set of seizures. So when we talk about his ability to work, his condition in terms of ability to work has been gravely affected. Once he had the injury, he had epileptic seizure. He has an epileptic seizure disorders. He had major epileptic seizure in the record. And that was at a point in time after the barrel factory job. So to compare to make an argument that Van Deventer's job in the barrel factory was allow him to be a permanent total to avoid that he get a similar job now, that's an apple and an orange. He's a changed person even from the barrel factory. He's worse. And it'd be more difficult for him to find employment. Thank you.
Ms. Ruth, then.
Thank you, Madam Chair. As noted in the DOC's response, we do not believe that the rateable seizure disorder has necessarily been established, although recognize that Mr. Keenley believes that that would be more appropriately determined post-release. I would note that the medical records indicated in 2016, immediate medical records after that incident did not show epileptiform features or seizure activity. But again, to the extent, as Mr. Keenley has proposed, keeping the seizure question open to determine functional, whether it actually is lasting functional impairment. The DOC does recognize in an abundance of caution, Mr. Van Deventer is on Keppra, which is an anti-seizure disorder medication.
Thank you. Are there any other questions? Any questions of Ms. Ruthven or Mr. Fishman? Okay, Mr. Keenley, do you stay with your recommendation?
Madam Chair, subcommittee members, I think that there, as I stated, there are a lot of components to this, but I think that there is at least some commonality. And so, in the interest of not holding this over, for a year or 2 years, I think that without any movement forward, I think, there isn't evidence for me to make a recommendation for total permanent disability. And there's not enough evidence in the record now for a seizure determination. So, I think, from my perspective, what we would typically do in smaller claims, or what I would typically recommend in smaller claims like this, would be to hold the entire claim over. But, again, given the length of the history of this claim, the impending release of the claimant, to hold everything over doesn't seem in the spirit of what is best for moving forward. So I think, like I said, the
Thank you.
20% and 20% is, again, sort of the minimum ascertainable amount, which is based on using numbers that show up in both the claimant and the Department of Corrections figures.
And that amounts to $43,200.
Correct, Madam Chair.
Is there a motion, committee members?
Madam Chair,
Senator Anderson,
how does Mr. Keenly want this worded if he wants to pay partially? So the claim is brought back up again in either next year or the 2 years afterward. How should the verbiage be in my motion?
Madam Chair, Senator Anderson, I would use the terminology for a minimum ascertainable permanent partial disability.
That we pay the James Van de Vender's claim of $43,200 with that verbiage that you just came forward. So moved, Madam Chair, with a roll call.
thank you, Senator. Is there any further comments or questions?
Madam Chair,
Senator Dornick,
so are we saying that we're not going to look at it until 2023 in this motion, or
we're not saying when we're going to look at it again or if we're going to look at it again, but we're saying that we're willing to pay a portion, the $43,200, with minimum portion.
Okay, so we're not addressing when they're going to hear it again, or that's up to the council then?
That's up to who's ever alive 2 years from now. Senator Anderson.
Madam Chair, I was just going to recommend that we have had in my past years have had claims committee hearing twice a year, and so we could have a claims committee hearing next spring at this time, and then again in the fall, and we wouldn't have to wait till 2023. But it's up to Mr. Keenly and whoever's the chair to decide what and when, if Mr. Van de Vender is released, and circumstances to his health care. So it could come up as early as probably either next spring 2022 or the fall of 2022 if we decided to have another claims hearing.
Right. And I'm not making any promises.
Oh, come on.
Mr. Keenly.
Madam Chair, just for the record, I just wanted to clarify that I don't set the agenda. I make recommendations to the chairs who
correct.
Set the agenda.
That's correct.
Madam Chair.
Representative Quam.
Thank you, Madam Chair. And for the newer members, what happens is it's not unusual to have something delayed to the future. And sometimes it's ready the next time you have a meeting, and other times it's not ripe for a decision. So I support the idea of taking care of what we feel confident in and that the appropriate actions will be taken by the future members of this committee. Thank you, Madam Chair.
Any further comments? Ms. Most, will you call the roll for the Anderson Amendment for $43,200 for minimum portion with the rest of the Mr. Keenly's language?
Yes. We'll start with Chair Murphy.
Yes.
Representative Frederick.
Aye.
Representative Quam.
Aye.
Senator Anderson.
Aye.
Senator Carlson.
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and Senate voted in favor.
And we've agreed to pay a portion of $43,200 to James Vandevender. You may all stand up. We're at a portion in the schedule that we can all stand up. And we can run somewhere, but don't everybody run somewhere until somebody comes back. Because we don't want you to leave the, the Zoom call. But do stand up.
Madam Chairman, am I excused now, or do I have to?
You can go and celebrate your birthday, and if you have a drink, have one on me.
I will. And then the last question of when we'll reconvene, I guess that someone will notify us about that for the other issues.
Mr. Keenly or his successor.
Thank you. Best of luck to the committee.
Not that he's leaving or anything. I don't know that, but who knows who's in what job 6 months from now.
Okay, take care.
Happy birthday.
Thank you a
Happy
million.
birthday, Mr. Fishman. Thanks for celebrating it with us.
Yeah, it was a learning experience. I enjoyed it. Thank you. Thank you for everything.
You could still stay for another hour because we have 20 more to go.
Well, you have a good day now.
Okay. Who's going to make motions? You're doing a good job, Senator Anderson. You picked up really quick when I called on you to say that. Dwayne's doing a good job too.
Madam,
Are we all back?
Madam Chair, the Senate Council, the Subcommittee Council had to step away for just a little bit. They'll be right back.
All right.
Madam Chair, I think if we're at the thank you, Madam Chair. I think if we're at the property claims section, I am inclined to, we all have seen the ones that are highlighted and designated. I'm inclined to, when the council returns, make a motion to determine the other ones not designated for polling out and discussion to be to take the council's recommendation on those. It's around 100.
Yeah.
Madam Chair, is Representative Quam talking about the different individuals that are highlighted in red for discussion on the ones that are in black that have been denied?
Yes.
Well, when council returns, I'm sure one of us will make a motion.
Yeah.
Madam Chair, I'm back if we're waiting
Good.
on me.
All right. We're ready to begin, and these won't take as long, right?
I hope not, Madam Chair. So starting with I think we'll, as we've typically done, we'll start with the property claims that I've marked for recommended hearing, and then if there are any other claims that after we do those, if there are any other claims that members would like to bring up, and then I think Representative Quam was already planning his motion to dismiss everything else. So if there are no objections to that plan, I will start with the Bugs claim. So claimant Bugs asked for $811.43 for compensation for missing items. Claimant was moved to segregation, then transferred to Oak Park Heights. Staff packed and inventoried claimant's property twice because of the transfer. Claimant had 5 bins of property when he was packed up. This exceeds the limit of 2 bins. The Department of Corrections gives offenders 30 days to direct DOC how to send out or dispose of excess property. Claimant has not given DOC any direction. Claimant's earbuds were disposed of because they were, quote, not allowed. DOC staff reviewing the claim determined the documentation was insufficient to determine if DOC staff correctly disposed of the earbuds and recommended compensation of $12.80. Claimant has a pair of prescription sunglasses he purchased while incarcerated in 1998. These sunglasses no longer comply with DOC policies. Presumably, these were allowed in 1998 when they were purchased. Because the DOC policy change has made them contraband, DOC may either continue to allow them in the facility or pay to have them shipped out. On all other claimed items, no compensation is recommended. The knee brace was marked as not present, and there's insufficient evidence that staff caused the loss. On the Quran and the trial appendix, there's insufficient evidence that a loss occurred, and the remaining items are not tracked and not reimbursable. Hearing and payment of $12.80 plus shipping costs on the sunglasses, if the Department of Corrections does not wish to grandfather them in, is recommended.
Is there a motion?
Madam Chair, I'd move to take the council's recommendation on this item.
Is there any further discussion? Oh no, I can't do that. Oh, okay, Ms. Most.
Yes, we'll start with Chair Murphy,
Yes.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
No.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Madam Chair, for the House, we have all in favor. For the Senate, we have 1 nay and 2 ayes.
Okay, so the motion is to deny the,
No. To pay it.
to be it. Oh. To pay it? Is that right, Representative Quam?
To take the recommendation by our council on this topic.
And I thought
Madam Chair, the recommendation is to pay the $12.80
$12.80
plus some shipping costs potentially on the sunglasses.
That's right. Okay.
Or to grandfather them, continue to grandfather them in.
Yes. Because we're denying the claim of $811.34.
Yeah, almost 800 of it. but
Yeah.
yes.
Okay, but to pay the $12.80. The motion is adopted. And a claim will be paid for $12.80 or whatever that is.
Madam Chair, the next claim on the agenda to recommended to hear is the Cabrera claim, and I'll defer. I know that there is an offer out. So I will see. I think it might be worthwhile to hear from Mr. Ehlers to see if there's any additional information on that, and then determine whether the subcommittee wants to hold on a recommendation or to recommend paying.
Mr. Ehlers.
Madam Chair, thank you. We did actually offer to settle this claim with Mr. Cabrera. He's received the offer. We have yet to receive a response from him. The offer was for payment of $22.50, the amount that he is seeking. So we were offering to pay his claim in full. So I expect that this claim will be resolved in the near future. So I, at this point, have not heard back from him, however, and so that's sort of where we stand on this claim.
So we should have a motion to
Madam Chair, we can
pay up to
make
$22.50.
Yeah, Madam Chair, I think that given that offer is already out there, I mean, this would basically being the subcommittee saying, yes, do that, which they're already doing. In which case, if he says no, I don't know why he wouldn't accept the full payment for his offer, but sometimes they've done that in the past. If they say no, then, or the Department of Corrections can update their offer saying the subcommittee told us to pay this, so this is your last chance, which I think is how that typically works.
Is there a motion
Madam Chair, so moved.
to pay $22.50?
Correct.
Ms. Most?
We'll start with
Libby,
Chair.
yes.
Representative Frederick.
Aye.
Representative Quam.
Aye.
Senator Anderson.
Aye.
Senator Carlson.
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and Senate are in favor of the motion.
And we are willing to pay $22.50 to Mr. Cabrera.
Madam Chair, the
Mr.
next claim is the Fox claim. Claimant Fox asked for $73.50 for missing sweatshirts and a cervical pillow cover. Claimant was moved to segregation. Staff packed and inventoried his belongings. Inventory sheets showed that his cervical pillow was present and sent to health services. There is no record of whether the pillow had its cover when it went to health services. The segregation intake form shows claimant was in possession of 2 sweatshirts when entering segregation. The sweatshirts are not inventoried or not reimbursable. Medical services staff suggest that the cervical pillow can still be used with a state-issued pillowcase. The claimant's cervical pillow is a cylindrical style pillow, approximately the same length as a standard bed pillow, and sort of, a round cylindrical pillow. If the subcommittee determines that the use of a state-issued pillowcase is an acceptable substitute, then denial is recommended. Hearing is recommended to make that determination.
Discussion. Motion.
So move to follow the recommendation.
To deny the claim. Representative Quam?
Correct.
Okay. Ms. Most? Murphy,
Madam
aye.
Chair. Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and the Senate are in favor of the motion.
We're recommending to deny the claim.
Correct.
Mr. Keenly,
Madam Chair, the next claim is the Fraser claim. Claimant Fraser asked for $1,368 for a lost wedding ring. Claimant was transferred between facilities. Claimant's pack-up inventory for transfer out of St. Cloud. Claimant's pack-up inventory for transfer out of St. Cloud includes his ring. The inventory sheet from his arrival at Rush City does not have his ring. There is no documentation as to who was in possession of the ring between the two inventories. Claimant states that DOC had possession of the ring. A note from a telephone call with an officer states that he always tells offenders to wear their rings during transport. DOC allowable property list sets a maximum value for a ring at $100. There is sufficient evidence to find that DOC may or may not have been in possession of the ring. Hearing is recommended.
oh, I don't know about this one. Do they wear their ring, Mr. Ehlers? Do they wear their rings on a daily basis?
Yeah, that is correct. Or Madam Chair, that is correct.
So how would the department have his ring?
From my understanding, so the process of his transfer, he would have been present outside of his cell as staff was packing his property. He may not have had his ring on at the time. However, we do caution offenders to wear their rings during transportation, given the fact that they are small items and can be easily lost. Mr. Fraser claims that a DOC staff member placed the ring in an eyeglasses case, and in a conversation with the facility, I confirmed that that was highly unlikely because they would not want to put a ring in with eyeglasses, given the chance that it could scratch the eyeglasses. Typically, if the offender refuses to wear the ring, they will place it in some sort of a cup or bowl that's easily sealable to make sure that it's not loose within the property or within their property bins. So that's the information I received from the facility, and my understanding is that he would have been cautioned to wear the ring, and that is in the abundance of caution to make sure that we're not losing those easily losable items.
And was there proof of how much the ring cost? That's what I was wondering when I read this last night. I thought,
Madam Chair, the maximum amount of sort of value for a DOC for that, and Mr. Ehlers can go into more detail, but there is sort of $100 limit is the wrong word, but value placed on those things for a number of reasons that, again, I'm probably not the best person to try to
Right.
come up with all of those reasons.
I don't know. And he was advised to wear the ring.
Madam Chair, there isn't the officer that packed his property does not specifically remember advising him, but he did advise me that it is his practice to always advise offenders to wear the ring to reduce the chance of it being lost.
Okay, is there a motion? Representative Frederick, you have a question?
Yes, Madam Chair. I'm just curious if an offender wanted to bring in a ring that was valued at $2,000, would they be allowed to have that?
That is correct. Offenders are allowed. I should restate that, Madam Chair. Excuse me. They are allowed a plain wedding band. So it depends on the type of wedding ring. But they are allowed to have that at intake and bring that into the facility with them. And regardless of value, we'll allow them to have that. And just speaking to what Jason had mentioned about the allowable maximum value, the issue there is, like I said, rings are easily lost and sometimes difficult to prove value. And it could be easy for an offender to potentially, purposefully lose a ring and file a claim for something that's a pretty exorbitant amount of money. So that's why we place that $100 maximum claim value and inform the offenders of that in the allowable property list that they have access to.
Senator Carlson.
Yes, thank you, Madam Chair. I guess I need to have a little bit of clarity on the policy here. We had a wedding ring disappear a few years ago where the person evidently wore it into incarceration and then was told that you cannot have a ring, you cannot wear a ring, and they took the ring and said that you have to tell us where to send it. And I think it was within 30 days, something like that, that you had to tell them where to send it. And the offender did not tell them within 30 days. And then when he woke up about this ring not being sent anywhere, the ring had disappeared. And I thought that the policy at that time was that an offender could not wear a ring and had to surrender it to be sent to some designated place that the offender designated. Is that a change in policy, or is that a difference in the place of incarceration or the type of incarceration? What's the policy on that?
Mr. Ehlers.
Madam Chair, Senator Carlson, that particular claim would predate my time. I'm not for sure what the specific underlying facts of that claim are. However, I can tell you that the policy as it exists now allows for offenders at intake to bring with them one plain wedding band. And so, it depends on what the particular underlying facts of that previous claim were. Maybe it's a wedding band that did not fit that description of a plain wedding band. So that could be, but I'm just speculating with that. But I can assure you right now, the policy is that they are allowed at intake to bring with them a plain wedding band.
Okay, thank you.
Was he Paul Bunyan sized? Because maybe that would add up to $1,300, but.
Madam Chair, I'm not sure.
Sounds to me like this one had diamonds. A diamond. A little tiny diamond. Senator Anderson.
Well, Madam Chair, I'm just interesting that it says here that that staff at St. Cloud put his ring into a little eyeglass container, and then he was given the eyeglasses, and then he asked for the ring, and the ring wasn't there after he got to his next location. And so it's curious that he go from St. Cloud to Rush City and lose it within, I'm guessing it can't be more than an hour or an hour and a half drive over to Rush City. But anyway, it's a little mystifying to me that
was he wearing his eyeglasses?
Well, the eyeglasses were in his, according to what it's written here, the eyeglasses were inside the case.
And that's how they get scratched.
So they gave him his eyeglasses when he left there, but when he asked for the ring, the ring wasn't there. I don't know.
Representative Quam.
Thank you, Madam Chair. And I think there was a stone involved in that other previous one. I don't think Jason was with the committee at that time. It may have been the retired chief revisor at the time, but my understanding is that we actually deviated from the specific, but did not go beyond. It was a modest adjustment to what we had given on the $100 limit. But in that case, I believe because of a plain band is less likely to cause certain injuries in a altercation. If you have a stone, I think it's more dangerous, and that might have been, that's my recollection of, there was a reason why it was not allowed and where a plain band was. And frankly, generally in this committee, we've stuck to the guidelines unless there was clear reason to deviate because of the specific case. And I'm inclined to stick with the guidelines in this case also. Thank you, Madam Chair.
So is there a motion?
Madam Chair,
Yes.
I make a motion that we pay the $100 minimum to Mr. Fraser and go for a roll call vote.
Really? Ms. Most?
Start with Chair Murphy.
No.
Representative Frederick.
No.
Representative Quam.
Aye.
Senator Anderson.
Aye.
Senator Carlson.
Aye.
Senator Dornick.
Aye.
Madam Chair, in the Senate, we have 3 all in favor of the motion. For the House, we have 2 against, 1 for.
So do we have to have 2 and 2?
I believe so, yes.
Mr.
That is
Keenly?
correct.
Mr. Keenly?
Yes, Madam Chair, for something to pass, it needs a majority of both houses.
Madam Chair, the claim's denied.
Claim is denied. Mr. Keenly?
Madam Chair, the next claim on the list is the Gibbons claim. Claimant Gibbons asked for $120 for disposal of religious items, 3 books and a rosary. Claimant was moved to a quarantine unit. His property was packed and inventoried. Claimant's possessions were over the 2-bin limit. There are conflicting reports as to what instruction the claimant was given to comply with the 2-bin limit. In complying with the 2-bin limit, claimant's excess property was noted on the property disposition sheet. Claimant gave staff authority to dispose of the excess property. Claimant then filed a grievance for being, quote, coerced into disposing of religious material. DOC staff investigated and determined that due to the uncertainty surrounding the situation, that DOC would remedy the situation by replacing the 3 books and the rosary. Claimant has refused this offer. Given the nature of the grievance claim, replacement of the items is a more appropriate response than reimbursement of the monetary value. Final offer of DOC's earlier offer is recommended.
Questions? Mr. Ehlers?
Thank you, Madam Chair. I would note too that Mr. Gibbons transferred to our Lino Lakes facility, and Lino Lakes is currently in possession of the items subject to his claim. So we have the ability to return those to him or certainly reoffer that as a resolution in this matter.
Oh, so the books in the Rosary are at Lionel Lakes?
I'm not certain about the Rosary. I do know the books are. I can certainly check. If the Rosary is not at the facility and not able to be returned to him, we can certainly, if you believe that is appropriate to grant that portion of the claim, we can certainly reimburse for that and offer to return the books as well.
And what did he refuse?
Thank you, Madam Chair. The facility at Moose Lake decided that it was appropriate to return the books to him. There was a communication sent to him with that offer, and he refused to have the books returned to him.
And they're the same books, same titles.
Madam Chair, that is correct.
What? I don't quite get it. And then what? But he made the claim. And then
Madam
you
Chair,
found the books at Lionel Lake.
Madam Chair, we had possession of the books the entire time. They were never lost. He decided not to include them in his 2 bins when he came into compliance with the 2-bin limit. Again, there was some sort of dispute around what was said during that time when he was repacking his property. That is why the facility decided to grant his grievance and allow those books to be returned to him. It's my supposition that he just prefers to have that money as compensation rather than the books returned to him.
Oh. Well,
Madam Chair, I'd move to deny.
Representative Quam moves to deny the claim. Any further conversation? Representative Frederick.
Just, Madam Chair, just to make sure I understand, if we deny the claim, he does not get the money, but then he gets the books? Is that what happens?
If he wants the books, he could get them. But he said he didn't want the books.
So, Madam Chair, then he could, so if we deny the claim, he doesn't get the money and the books could either be donated, disposed of, whatever, essentially, is what we're talking
Right.
about. Okay.
But I would think he should be offered the books back again.
Right. Yep.
Without money.
Right.
Madam Chair, I will ensure that offer is made to return the books to him and explain to him basically that the claim is denied. The subcommittee heard the matter and has denied the claim for compensation and but recommended that we reoffer to return the books. And then once we receive an answer from him, we will, if he says no, then we'll follow the next steps and either dispose of, donate.
Do you know who the author is?
I believe the 2 of the books are Bibles. And one of the reasons I think the facility granted that grievance is because they were religious materials. So yeah, there's disputes as to who the author is, I guess.
Okay. All right. Murphy, yes. To deny.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and the Senate are in favor of the motion.
Thank you. Mr. Keenly?
Thank you, Madam Chair. The next claim is the Hintz claim. This is another ring. Claimant asked for compensation for a confiscated ring. Claimant was found in possession of a silver wedding band. Staff checked his inventory and no ring was marked. Staff then confiscated the ring. In communications with the claimant, staff suggested that the ring could be sent out. When claimant asked for the ring to be sent out, staff informed him that it could no longer be found. Claimant has moved between facilities numerous times. Claimant does not have a ring marked on any of these documents. Given the amount of documentation showing that claimant did not possess a ring, it is highly unlikely that the ring belonged to the claimant. However, if the claimant had been able to establish that the ring was his through additional documentation, staff would be responsible for the loss of that property. The maximum value that can be given for a ring is $100. However, based on the totality of the evidence, hearing and denial are recommended.
Okay.
Madam Chair, so moved. Denied.
Senator Anderson moves to deny. Murphy votes to deny.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson, Senator Carlson,
Sorry, aye.
Senator Dornick.
Aye.
Madam Chair, both the House and the Senate are in favor of the motion.
And the claim will be denied for Mr. Hanks. Moving right along.
Madam Chair, the next claim is the Keys claim. Claimant Keys asked for $105.06 for a missing tablet charger and canteen items. Claimant was moved to segregation. Inventory sheets show that he had his tablet with him when he went to segregation. Staff finding a tablet charger but no tablet when claimant's cell was packed disposed of the charger. DOC offered $17.17 to replace the charger that had been improperly disposed of. Claimant rejected that offer. Claimant's other items are canteen items and are not tracked and are not reimbursable. Hearing, reoffering the $17.17 and denial of the remaining claim is recommended.
Questions? Motion?
Madam Chair, I would move that we do the recommended 1717.
Quam moves to deny and pay $17.17. Murphy votes aye.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and the Senate are in favor of the motion.
Okay. Mr. Keenly?
Madam Chair, the next claim is the Lucero claim. Claimant Lucero asked for $670.49 for missing electronics, eyeglasses, clothing, personal care items, and 2 canteen orders. Claimant was moved to segregation from a double occupancy cell. Because of short staffing, his property was not packed and inventoried until the next day. DOC reimbursed him for the canteen order he received the day before he was moved to segregation. Inventory sheets show that claimant's television, remote control, and clock radio were missing. Because of the delay in packing and inventorying claimant's electronics, DOC offered $280 as reimbursement. Claimant denied that offer. The segregation intake sheets show that the claimant had his glasses. All other claimed items are not tracked and not reimbursable. offenders have a responsibility to secure their own belongings. The tracked electronics and canteen order from the day before his move to segregation are the only items that the DOC can reasonably infer that claimant possessed. The DOC has already reimbursed claimant for the canteen order hearing, and reoffer of the $280 is recommended.
Mr. Ehlers,
Madam Chair, I believe that is a reasonable recommendation, and we would agree to reoffer that $200 or $280 amount.
okay. Any other questions or any motions? Representative Carl or Senator Carlson.
Madam Chair, I recommend that we pay the portion, the 280 recommended portion of this claim and deny the 670.
All right.
Call for roll call vote.
Murphy votes yes.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson.
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and the Senate are in favor of the motion.
Okay, the denial, we deny the claim and we are willing to pay $280. Mr. Keenly.
Madam Chair, the next claim is the Meyer claim. Claimant Meyer asked for $16.25 for damaged headphones. Guards searched claimant's cell after a tip that he had a shank. 1 hour after the search, claimant showed a guard that his headphones were broken. The officers that searched the cell were interviewed and stated they did not break the headphones. Had the headphones already been broken when the inspection occurred, they would have been confiscated. This is a very tight timeline for damage to have been caused by claimant or others, and hearing is recommended.
And the hearing is recommended because the tight timeline?
Largely because had the headphones been broken, and it's somewhat unclear what was broken about the headphones, but had they been already broken when it was investigated, they would have been confiscated as contraband. So, if they would have had to go in and then break them, or they didn't notice them, which is a possibility as well. There's just not a lot in the record to make a determination one way or another that the headphones were there. So with a lack of evidence, I've recommended hearing on this one because of how short the time frame is. Although I haven't recommended paying this, it's mostly just a factual issue.
Mm-hmm. Mr. Ehlers, anything to add?
Madam Chair, I would note that an incident report that was submitted with the claim describes the damage as the headphones having one of the earpieces completely broken off. To me, this suggests that it was fairly extensive damage, and had the officers encountered it, it would have been obvious enough for them to immediately confiscate that item. So just given the extent of the damage, I think it would be highly likely that they would have noticed it had that damage been present at the time of the search.
Now here's headphones for $16.25, and a little while ago we were asked to pay $250 for some headphones.
Madam Chair, I'm unsure that we offer any headphones that are valued at $250. Typically, they are around the $16 to $20 range. Although I believe you can get some that are up to 40, if I'm not mistaken, but I'd have to confirm that.
Okay, is there a motion?
Madam Chair, I move that we pay the $16.
That we pay?
Yes, Madam Chair.
And Representative Frederick, you're making that motion?
Yes, Madam Chair.
Okay. Ms. Most,
Start with Chair Murphy.
well, I don't want Representative Frederick's first motion to go down, so yes.
Representative Frederick.
I appreciate that, Madam Chair. That's an aye.
Representative Quam.
No.
Senator Anderson.
No.
Senator Carlson.
No.
Senator Dornick.
No.
Madam Chair, all in favor in the House and all against in the Senate.
Well, it went down anyway.
Madam Chair,
Representative Frederick.
Madam Chair.
Representative Quam.
Thank you, Madam Chair. I believe that I may have not voted the way it was recorded, but it doesn't make any difference in the final outcome. I will endeavor to speak more clearly next time. Thank you, Madam Chair.
Okay. Mr. Kinley.
Madam Chair, the next claim is the Middlebrook claim. Claimant Middlebrook asked for $1,058 for confiscated shoes, glasses, knee brace, fan, and remote. Claimant was moved to segregation. Staff inventoried his property. Property sheets showed that the fan and remote were broken or altered. During subsequent investigation, the department took responsibility for the damage to the items and offered to reimburse claimant $35.44 for these items. Claimant rejected that offer. The shoes, glasses, and knee brace were confiscated for claimant because they were not on his inventory sheets. Claimant had been transferred to Faribault in June of 2017. At intake, claimant did not have any of these inventoried items. There is no record of claimant purchasing these items while at Faribault. DOC policy requires confiscation of tracked items that are not on the inventory sheet. Hearing, reoffering the $35.44 and denial of the remainder of the claim is recommended.
Mr.
Madam Chair, I
Ayers.
would so move. Oh,
Madam Chair, I believe that is a reasonable recommendation to reoffer that amount.
Okay. So all this stuff totaled was over $1,000. Okay.
Madam Chair, a large amount of that is Air Jordan shoes that he valued at $749. I can assure you there are no shoes that we allow offenders to purchase that are even remotely close to $749. And I don't even believe that we approve offenders to purchase Air Jordan shoes. I don't believe they're on the approved list that they can purchase.
And grandma can't send him a pair of Air Jordans either if they're not on the list. Is that correct?
Madam Chair, grandma can't send him any shoes. He would need to purchase the shoes
from your vendor.
From the vendor, which I believe is East Bay. And there's a limited number of options that he can choose. And Air Jordans are not one of those.
Okay. Motion?
Madam Chair, I would move to move for the recommendation, which is the what, 3544.
Mm-hmm.
Deny the rest of the claim.
And deny, but pay the 3544. That's the motion?
That's a motion, Madam Chair, because it's pretty well evident what's allowed and not, and that's why they have an inventory.
Right.
And So that would be my motion. Thank you, Madam.
Murphy votes yes.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and the Senate are in favor of the motion.
And we will deny the claim and pay $35.44. Representative Keenly, or Mr. Keenly.
Madam Chair, the next claim on the agenda was actually settled by the DOC, so we will not do the Morgan claim.
Oh, good.
So we'll skip to the Reavers claim.
What did DOC, what did they agree to?
Madam Chair, we agreed to reimburse him $95 for the Nike Air Force One shoes, which is just a portion of his full claim, but he did sign a release, and that claim is now resolved in full.
Good. Thank you. That saved us almost $5. Mr. Keenly.
Madam Chair, the next claim is the Reavers claim. Claimant Reavers asks for $100 for compensation for items shipped to the wrong address. Claimant asked staff to send out a package to his daughter. The package included a birthday card, a drawing, colored pencils, and a bracelet. Staff mixed up the shipping labels and his package was sent to someone else. DOC offered $10 to settle the claim. Claimant rejected the offer. Hearing is recommended.
Mr. Ehlers.
Madam Chair, I believe the issue in this case is sort of relating to almost sentimental value of the items sent to his daughter. We offered to pay for the raw materials of what was lost. However, we're not in a position to make that call as to sentimental value, and we'll leave that to the wisdom of this equitable body. So,
Madam Chair, didn't we hear a similar? I believe the difference was these were things that were art that was done and sold, as opposed to a relative and the sentimental. I'm wondering if staff would remember what we had determined, with the artistic thing like this and raw materials. What sort of precedent have we done in the recent past?
Madam Chair, Representative Quam, I do remember a claim from a couple of years ago where I believe there was a painting sent to I believe it was a niece. I would have to go back and look for that record. I don't remember exactly what year it was or exactly what the recommendation was, but I could certainly dig into that to try to find out. But yes, there certainly was, again, something, a very similar type claim to this.
But they don't have, nothing was returned, right?
Madam Chair, the facility reached out to the individual where the property was mistakenly sent and asked them to return those items to the facility. However, they did not receive any response.
Madam Chair.
Representative Quam.
Thank you, Madam Chair. I'm wondering, the offer was made for materials. I'm wondering if a better set of, if it was paints or, whatever the materials, sort of it's hard to throw a dollar figure like you said, but in compensation, getting a slightly more complete artistic, material list. I'm just trying to bounce off if any similar things have been done in Mr. Eller's, maybe I don't know what options they have. So I'm sort of curious as to, what options, a small upgrade in materials, if that's ever been done.
Madam
Mr.
Chair,
Ellers.
Madam Chair, Representative Quam, I don't have any specific knowledge of any other settlements that we've made to that effect. I believe his claim was, or our offer was, I believe colored pencils. I can't remember the exact. Yes. And some drawing paper. I believe that's what we sort of used to calculate it. I don't necessarily know what type of art Mr. Reavers engages in, whether, if an upgrade would be giving him paints or something. I'm not entirely sure, or more drawing paper. We just wanted to put a figure on the raw materials that we could discern. And that's how we arrived at the $10 amount.
Mr. Kinley.
Madam Chair, members, the Representative Quam's recollection is very good. It was claim heard in 2018, the Gustafson claim, where he asked for $499 and for a lost drawing that was shipped. Let's see the facts on this. Drawing had done for his niece. He insured it for $499. And while the shipping label was printed, UPS never processed the package and it could not be found by staff. The offer there from the department was $50. The claimant rejected that. And then it looks like from the minutes that the subcommittee recommended reoffering that $50.
But this time the department only offered 10? Is that correct?
Madam Chair, that is correct.
And there was a bracelet in there too, right?
Madam Chair, the bracelet that he is claiming is missing was not on the property disposition record showing the items that were sent out from the facility. So we could not confirm that the bracelet was among the property that was erroneously sent to the wrong address.
Would the $10 just cover the costs of the mail? Of
Madam
sending
Chair,
a package?
Madam Chair, the $10 amount was calculated by the facility to reimburse him for those raw materials of what he sent, and some colored pencils, et cetera, that type of thing. I don't have the precise how they reached that calculation, but was informed that it is for the raw materials that they could confirm.
Is there a motion? Questions? Senator Dornick? Oh,
Madam Chair,
yes.
I'm thinking we should reimburse him maybe the $50 like the last time. See if he would. That's what I'm thinking. I'd make a motion to reimburse him, offer him the $50.
Okay. Senator Carlson?
Thank you, Madam Chair. And I would agree with Senator Dornick. $10 is not very much. And there was a birthday card in there, and as well as the drawing materials and his drawing, and it was for her birthday. And I don't know if you read all the background on it. He found out about it from another inmate because the other inmate got the materials that he had sent, and
Yeah.
and so it was a switcheroo. I don't know why they wouldn't return them, but I guess lots of things go unexplained. But I think that the $50 is a reasonable amount.
Better than 10.
Yes, yeah, and
Yeah.
I move that we deny the $100 and pay $50 for this claim.
Okay. Murphy votes yes.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and the Senate are in favor of the motion.
Okay, we're denying the claim and offering $50. Portion. Mr. Neal Keenly,
Madam Chair, the next claim is the Schulte claim. Claimant Schulte asked for $259.48 for lost items. Claimant was released from a facility following a court vacating his sentence. Claimant states that he asked for several items of his property to be sent to his brother-in-law. DOC has no record of the request or records of the disposition of claimant's property. DOC offered the claimant $244.73, which is the cost and tax on the items he claims were lost. Claimant refused the offer. The difference between what claimant asked for and what DOC's offer is the shipping cost that claimant would have paid if the items had been shipped out, and a small difference for miscalculated tax. Because there is no record that claimant was charged the shipping fee, hearing and reoffering the $244.73 is recommended.
Madam Chair,
Senator Anderson,
I move the request of that the $244 be reoffered to the claimant, and that the claim be denied for the $259.
all right. Any further discussion? Murphy votes yes.
Representative Frederick,
Aye.
Representative Quam,
Aye.
Senator Anderson,
Aye.
Senator Carlson,
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and the Senate are in favor of the motion.
Okay. Let's try that 244.73 again. And then $8 more than that. Okay. Mr. Keenly,
Madam Chair, the next claim is the waiter's claim. There is also an offer out on this, so I'll defer to Mr. Ehlers to see if there's any update on that before I go into the summary.
all right. Mr. Ehlers,
Madam Chair, Jason is correct. There is an offer for $40 for the headphones currently out. He didn't submit any proof of the value of the headphones. And like I said, typically they're limited to around $20. And I just confirmed that by looking at our canteen sheet. However, in the interest of resolving the claim, I decided that we would just go ahead and offer that $40 that he requested for the headphones, and have yet to receive a response from this inmate to our offer.
okay. Is there a motion? Questions?
Madam Chair.
Representative Quam,
Thank you, Madam Chair. So the actual value is 20. He hasn't, he rejected the 40, but was being offered again. I'd be inclined to make a motion to deny and do a partial payment of 20.
Any other comments?
Madam Chair,
Senator Dornick?
I agree. I make a motion to just offer him the 20. They're only worth 20. I think that's what we offer him.
Okay. Okay. Representative Quam, do you want that as a motion?
The senator and I believe made the same motion, and therefore I vote aye.
Well, I didn't hear you say that it was a motion, but okay.
I make a motion to pay him $20 for the headphones.
And deny the 470 and pay 20. Murphy, aye.
Representative Frederick.
Aye.
Representative Quam, you had said.
Aye.
Yes. Yeah. Senator Anderson.
Aye.
Senator Carlson.
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and Senate are in favor of the motion.
Okay. One more motion.
Madam Chair, the last claim that I had recommended for hearing is the Yang claim. Claimant Yang asked for $280 for a broken television. Claimant was moved to segregation. Staff packed and inventoried claimant's property. Inventory sheets showed that the television was present, but there was no indication whether or not it worked. Claimant tried to use it at pickup and it did not turn on. Claimant purchased a new television for $257.10. DOC offered this amount and claimant rejected the offer. Rehearing and directing DOC to reoffer the $257.10 is recommended.
Madam Chair, I would so move.
Okay, Representative Quam moves to accept the deny and pay $257.10 portion. Any comments? Murphy votes yes.
Representative Frederick.
Aye.
Representative Quam.
Aye.
Senator Anderson.
Aye.
Senator Carlson.
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and Senate are in favor of the motion.
Madam Chair.
Representative Quam.
Seeing that we have covered all of the noted, highlighted, and suggested pullouts, I would move that the remaining claims be denied.
Mr. Keenly.
Madam Chair, if there's no other claims that members would like to bring up, then I think that's an appropriate motion.
Is there any other cases that should be brought to our attention? If not, Murphy votes yes.
Representative Frederick.
Aye.
Representative Quam.
Aye, aye.
Senator Anderson.
Aye.
Senator Carlson.
Aye.
Senator Dornick.
Aye.
Madam Chair, both the House and the Senate are in favor of the motion.
Thank you very much. Thank you for all those that are tuned in. Thank you for the staff for your good work and your great preparation of the materials. And the 3 binders, which we've all read in their entirety. Thank you, Mr. Keenly, for your updates from time to time and from the answering a question, even at 10 o'clock at night to prepare for this. I've enjoyed the evening and the experience a lot. Representative Dornick and Senator Dornick and Representative Frederick, you are now initiated into the Claims Commission. And
Thank you,
that is
Madam Chair.
That is a very close group of people that come together and make good government in at least once a year, twice a year, every once in a while. And we do good work from this. The agencies that are here, excellent work. And you've all been initiated now, so we won't be new next time.
Madam Chair, thank you.
It's been a good evening. Thank you for your wisdom. And thank you for your compassionate hearts. Good work, everyone.
Thank you and good night.
Thank you.